Callis, can I see you, if you don't mind?
Yes. Am I on?
We want to see you, but can I see you?
Am I on?
We can hear you.
You never look so good right now.
Oh, you smart butt. Hold on, let me see. I don't know why. Is that better?
No, we can't see you. I'll
I don't know why. I keep-
Counsel, we can't include Dr. Callis as president until he's on camera.
Roger that. That's all I was
The law-
asking him on
The
camera.
law dictates that.
Okay, we still got a quorum. Michael, are you there? Can you work with Callis on this? Is he on? He's on?
On 50. Council, point of order. He was just born right there. How can he be shown right now?
I don't know why the camera, it's showing me. I don't know why it's not working.
Why don't you reset? Can you
I am.
log-
I'll do that. I'll do that. Go ahead. All right.
Okay. All right. I tell you, we're going to move forward, and then we'll just add. When y'all keep an eye on that for me when you pause that?
Yes. Am I
I'll
on?
make a note to see you. All right. We're off to a contentious start at 8:40.
Am I on?
Time we will have invitation by Commissioner Hine, and you're welcome.
Oh, you smart butt. Hold on, let me see. I don't know why.
O Lord, the foundation of your throne is righteousness
Is that
and
better?
justice. Please
No, we
lead
can't
us
see
and
you.
guide
I
us
don't know why.
today as we discuss these important issues with wisdom and discernment. In Jesus' name we pray. Amen.
Amen. Why don't we call roll, please?
Yes, sir. We can't.
Commissioner Sujit
include Dr.
Rockstrom?
Callis as
Present.
president until he's on camera.
Commissioner Lori
Roger that.
High,
That's all I was
The law-
asking on
the
camera.
law dictates
Commissioner Nora
Okay, we still got a
Castaneda,
quorum. Michael?
Dr. Gary
Can
Wesson,
you work with Callis on this?
Dr. Ray Callis, Vice Chair Tom Butler,
Here.
Chairman Rick Figueroa.
Here.
Council, point of order. He was just born right
They
there.
were
How can he
present.
be shown right now?
We have a quorum.
Dr. Wesson will be adding on.
I don't know why the
9:30
camera, it's
after
showing
his
me. I don't know
program,
why
and
it's not working.
We'll figure out Dr. Callis in a minute.
Okay.
All right. I need a motion for.
I am. I'll do that. I'll do that. Go ahead. All right.
Second? Okay. All in favor, say aye. Opposed? Motion carries. All right, for those in person, the audience must remain quiet because their microphones in the ceiling and very sensitive, and you can pick up a whisper. We go to Commissioner, go to item C, public comment. We are accepting public comments in writing in person. You received 2 in writing, and then there's few in person here, 3 in person. So if anyone's here wishing to address the commission on a matter that is not on the agenda, you are here to contest the case or rule. Amen. We'll call you up when that is on the agenda item. If you want to speak, please fill out a public comment form and turn that in. Okay, so we're gonna go with
Commissioner Nora
Kristen Cook.
Castaneda,
Cook.
Yes.
Dr. Gary Wesson, Dr. Ray Callis,
I'm gonna read some instructions to you.
Absolutely.
Okay. Thank you for being here. Please say your name and who you represent. You have 3 minutes to speak. Please understand the commission are not allowed to ask questions or engage in discussion with you about anything that's not specifically on the agenda. Also understand that commissioners cannot hear any information about a pending complaint or enforcement case because we may be the ultimate decision maker on that case. Do you understand us?
Absolutely.
All right, go ahead.
Before Mr. begins, we usually have microphones on these tables so that the public can pick up the comments.
Can they hear them from the?
Can they hear?
ceiling?
Can
the
they hear?
microphones are in the ceiling.
Okay,
I
okay,
think that's it right there.
fantastic.
I'm not gonna have it. That's it. All right, Ms. Cook.
You ready for me?
Yes, ma'am.
Absolutely. Commissioners, my name is Kristen Cook, and I am a founding member of Moms Advocating for the Moms Alliance and a past client of licensed midwives in the state of Texas. I am here today because Texas mothers and babies are suffering, not because of chance, but because of a system that fails to protect them. TDLR claims to safeguard Texans, but I am alive today despite their lack of due diligence, not because of it. I have spoken with too many mothers who barely survived and too many who have lost their babies, all while midwives dismiss their concerns as variations of normal. But let me be very clear. Mothers do not suddenly become critically ill. Healthy babies do not just die. In most cases, there are warning signs, clear clinical indicators that trained professionals would recognize, yet Texas midwives are not required to have medical training that would prepare them to act before an emergency unfolds. Instead, TDLR allows midwives to oversee high-risk pregnancies when their training is limited to low-risk births. Regulations are outdated, evidence-based standards are ignored, and informed consent is not truly given to families making life or death decisions. And when tragedies do occur, the oversight process is deeply flawed and it takes too long. Complaints are reviewed by individuals with no medical expertise, mostly. Expert witnesses who should remain impartial often hear about cases from the community, creating conflicts of interest before they even review a complaint. No other medical profession operates in this manner. We are not here to abolish midwifery. This is not our goal. We are here to make it safer, to make it a viable option for Texan mothers and their babies. But midwifery is only a viable option when it is backed by strong evidence-based standards and safe regulations. Right now, Texas is failing them. Texas is already in a maternal and infant mortality crisis, and TDLR plays an integral part in reducing mortality rates in the state. Loose regulations and lack of oversight are costing lives. We ask you to make change because we know this is not the TDLR way. We ask you to protect Texan mothers and their babies because no mother should have to stand here begging for basic safety she was promised, and no mother should ever have to go home without her child. Thank you so much, Commissioner.
Thank you.
Absolutely.
An very late. Very late. Thank you. Thank you, Commissioner. Can we make a note, Dr. Callis?
I do.
Thank you. Thank you, Ms. Coogan. Amanda Calcutt? Good morning, ma'am.
Good morning.
Do you remember the instructions I just instructed?
Yes.
Okay, go ahead.
My name is Amanda Calicut, and I am also one of the co-founders of Moms Advocating for Moms Alliance. Our organization was founded out of a deep concern for the standard of care and education for licensed midwives in Texas. During my own experience under the care of TDLR licensed midwives, I witnessed firsthand alarming practices that jeopardized the health and safety of mothers and babies. The birth center I used was transferring first-time mothers to the hospital at a rate exceeding 70%, often after labors lasting 60 to 100 hours. Many of these transfers ended in an emergency cesarean. Additionally, there were frequent failures to diagnose preeclampsia and gestational diabetes, as well as common occurrences of meconium presence, sepsis, chorio, dehydration, hemorrhage, and devastatingly, loss of life. While I understand that complaints against midwives constitute less than 1% of all complaints received by TDLR, I urge you to consider the severity of the complaints. How many other professions that are licensed by TDLR receive complaints citing severe medical negligence and death? Allowing midwives with open investigations involving loss of life to continue practicing for 2 years or more is a disaster waiting to happen. If another injury or death occurs under their care, knowing TDLR was aware of the history, what does that say about the agency's responsibility? In the past 2 years alone, I'm aware of 7 infant deaths and 1 maternal death linked to licensed midwives who are still practicing today, and in some cases, teaching the next generation of midwives. Furthermore, I must express deep disappointment in the communication or lack thereof from TDLR's executive team and general counsel when it comes to protecting consumers. TDLR's mission is to earn the trust of Texans every day by providing innovative regulatory solutions to their licensees and those that they serve. Frankly, I do not believe TDLR is providing innovative solutions, nor do I believe the agency is doing all it can to protect Texas mothers and babies. As maternal mortality and morbidity rates continue to climb, TDLR must recognize its role as part of the problem and its duty to be part of the solution. I urge you today to seriously consider updating and strengthening the rules and standards for midwifery licensure and practice, and to commit to ongoing evaluation and improvement of these standards to ensure the safety of Texas families.
Thank you, ma'am.
Thank you.
Appreciate your time. Elizabeth Winfrey here. You understand the rules?
Yes, sir.
Thank you.
Good morning. Thank you for giving me the opportunity to speak with you today. My name is Elizabeth Winfrey Keeling. I'm a mom of 7 whose last home birth ended with a child having a birth injury. I would like to point out issues with your midwifery department that need immediate attention. It should be mandatory that CPMs carry malpractice insurance. Even though they provide a lot of the same services as CNMs and OBGYNs, they are not held to the same medical malpractice standards when mistakes are made during a home birth. It is impossible for a home birth mom to obtain legal counsel. Because of this, women should know that if there is a mistake made, midwives are human. There is absolutely nothing that they can do. This board should be honest with consumers about the possible consequences of using an uninsured provider. It should be mandatory for all home birth outcomes to be reported to the state. According to TDLR and hospital staff, transfers that lead to injury or death are counted against the hospital's statistics. TDLR is struggling to enforce midwifery regulations. I was a licensed cosmetologist, so when I hear TDLR, I think of educational requirements, set regulations with no wiggle room, surprise inspections to ensure that rules are being followed, and fines given religiously for infractions. This was to keep my customers safe, not to limit me as a hairdresser or to limit consumers' access to my services. TDLR is unable to monitor if CPMs are abiding by the regulations set for them, like carrying life-saving equipment to every single birth. When victims contact TDLR with hard documentation that violations were made, the likelihood of a midwife receiving a fine is still slim, even with a written confession. Mandatory case reviews should happen in the event of a stillbirth, infant and maternal death, or injury. These reviews could be a way to improve midwifery care for every client, for clients, and bring to light reoccurring safety issues that need to be addressed. Every death should prompt some sort of internal board review. TDLR needs harsh penalties for midwives that alter patient medical records after an emergency transfer or during the complaint process. TDLR should have a professional code of conduct for their CPMs to follow during the complaint process. There are no ethical guidelines prohibiting midwives from using their close patient relationships to persuade a mother from filing a complaint. Matter experts should not be the judge and jury on complaints. An expert should hold a higher level of training and accountability than those under investigation. Your matter expert should be an unbiased third party that does not hold membership to an association in common or attend training with the midwife under investigation. TDLR should be reaching outside of this tightly knit community where often victims' tragic birth stories are modified and shared freely in the name of education or to publicly validate the CPM's actions. Victims should be allowed to see all evidence and reports used to determine the outcome of their complaint, including the matter expert's report. There should be an avenue for consumers to file complaints against TDLR's prosecution department for not following their own procedures. There are no checks and balances. You rely on consumer complaints. Doctor and hospital staff complaints are being automatically dismissed, when in every other scenario, they are trusted, mandatory reporters. Doctors often aren't willing to speak about what did or did not happen where a medical professional was not present, making it almost impossible for victims to get a doctor's statement for their complaint. Victims are not filing complaints because they are being told by the midwives they love and trust that what happened at their birth was unpreventable. Because sometimes these things just happen and preventable tragedies don't occur at home births. Your complaint process is highly flawed and needs immediate attention for consumer safety.
Thank you.
Thank you, Ms. Keel.
Thank you for your time.
Thank you for, you didn't go on her. We appreciate you.
Mr. Chair, can I have? They won't have to do
Yeah,
that.
we can.
Ms. Keely,
Yes, sir.
can I have your notes, please?
Yes, sir.
Do you have another copy?
Oh, yes.
Yeah, if you have notes that you want to send to us, you're welcome to give them to us.
Absolutely,
I
right
appreciate-
now.
Yes,
Okay.
thank you so much.
After you can send it to, you can extend the staff and forward them to us, each commissioner. Thank you for your time, ladies. Great idea.
Thank you.
Thank you again. All right, commissioners, we're gonna move to, item D, executive session. We'll go down to executive session to consult with our attorney under section 551.071, subsection 1, 551.071, subsection 2, 551.074. The time is 8:54. After executive session, we'll take a break and come back here. Doug, 45?
We have a couple of I think, big items to discuss. I'd say we probably need at least
10 o'clock?
hour 15.
So 10 o'clock, we'll come back, we're gonna come back a little later. We'll come back at 10 o'clock, pick up with the action items and the executive sessions, and then begin our contested cases. We're gonna do this here, or we're gonna do it,
Yeah, we'll leave.
okay, we'll do it here?
Yes.
Okay. Get out.
Well, I think-
Yes, sir. Yeah, one over. All right, the time is 10:14. And we're gonna back from executive session. And there were no action items needed from executive session. Yvonne, can we recognize that Dr. Wesson has been added?
Yes, sir.
Okay, Commissioners, we're on item F, the minutes.
So moved.
For a second.
Second.
All in favor, say aye.
Aye.
Opposed? Motion carried. Item G, Legacy Systems Replacement Project. Charles? John?
I like this table.
You like that too?
You don't have to look at me.
I go to the center.
Put me on my side.
Maybe. All right, guys, you have floor.
Commissioners, this is agenda item G. The RFO issued to replace the legacy systems, referred to as LSR, LSPR, RP. Before we get into the actual discussion about the solicitation, I kind of want to make the record on this process. And in making the record, I think the record should show that.
Make sure you guys introduce each other.
Oh, sorry. It's Charles Johnson, Deputy General Counsel, and John Fowler.
John Feller, Chief Information Officer.
Thank you. Go ahead, Charles.
Okay. The couple points to be made on the record. One is that this is still an open solicitation. And so with an open solicitation, there are limitations that's what can be discussed in public. And the reason for that is because this is not a kind of rubber stamp. This is not a process where we make a recommendation and you vote on a recommendation. This is a process based upon facts and analysis, data, and which can reveal in this open meeting, in the event that this offer is not approved, will give a competitive advantage to anybody else in this process. And so for that, one of the reasons this discussion will be limited to what can be discussed in public, the reason that I just discussed. And there, if you recall, there was a solicitation we canceled. And when that solicitation was canceled, vendors sought to obtain those records. And we submitted a brief to the AG's office to say that those records should not be released because we intended to issue this solicitation. So the two solicitations are tied together. The Attorney General agreed, and those records have been confidential since that solicitation was canceled. And so I say this so that everybody is aware that the discussion will be limited to what can be discussed in the public. And there's going to be a perception that we have not discussed the facts. And so as part of this record, I think it should reflect that each of the commissioners was provided an independent briefing to discuss the confidential materials, to talk about the offers, to ask questions, to become informed about this process. So I think the record should reflect that your discussions today will be based upon informed discussions, and that whatever is decided today, and we have no idea what you're going to decide because that's within your purview. But those decisions will be based upon known reasoned justifications. And when this process is done, when a contract is signed, most of those documents will become public. And so that is the point in time when the public is aware of the vendors, pricing, scores, the whole 9 yards about this process. And so I want to make the record clear that your discussions today are informed on the facts. And with that, I'm going to.
I need to also, this is standard operating procedure.
Yeah.
Behavioral stage.
This is the process. And we have made painstaking efforts to stay within the lines. And there were hard decisions made in this process. Those decisions were rational. And I think that the outcome and the recommendation that we will bring to you today will reflect that. And John Fowler will walk you through that process. And so the record is clear that this was not given the value of this contract, it dictated the process that will be explained to you this morning and will become a part of the public record. And ultimately, the pricing and those issues that are sensitive also become public, but not at this time. So, John?
Thank you. Good morning, Commissioners. John Fowler, Chief Information Officer. So to Charles' point, state procurement mandates several things that occur of a project of this size. Anything over $5 million is considered a major information resource project, or MERP, as we like to use acronyms. And for MERP, one of the very first things we had to do is develop a business case, submit that business case to the QAT team for review. The quality assurance team is comprised of individuals from several other agencies, including DIR, the State Auditor's Office, the Legislative Budget Board, the Comptroller. They reviewed that business case. We were given approval. We developed an RFO. That RFO was publicly posted. That RFO contained several high-level objectives in terms of what, as an agency, we needed to pursue. In terms of project objectives, we specifically mentioned that we wanted an existing solution. We did determine through market analysis that licensing is a domain where vendors exist and they produce solutions for this domain, specifically for our business function. So high-level project objectives included our overall functionality. We did include the fact that while we were focused on the licensing portions of TDLR, that we wanted a solution that included greater functionality that we could include down the road, which includes enforcement inspection operations. In fact, we went to, in the development of the functional requirements, we included those as optional functional requirements so that vendors had an opportunity to respond to tell us in the future how those functions could be incorporated to the overall solution. So we made sure that from a guiding principle that vendors could meet our functionality, our size and scope, because of the depth and breadth of the TDLR functionality. One of the other key underlying factors was we wanted a system, we demonstrated this and asked them to prove the capabilities in terms of change, because we know of anything, things will continue to change, whether it's additional regulation, deregulating, changing fees, adding programs, adding licenses, that we wanted a system that was flexible and met our needs because we know that we'll be asked to implement change. Additionally, the RFO included specific business objectives. Those objectives included a single secure portal or solution for all of our customers, both internal and external, to utilize. For us internally, that will help us improve efficiency, because today we have multiple disparate licensing systems that all perform the same basic functions. We've inherited those systems, as you're familiar with, over time, as programs have been moved to TDLR. Rather than incorporating them into a single system, we've always just adopted those systems. And so when the phone rings today, our customer service team, they don't know which system they even need to go to log on to until they understand what that person is inquiring about. If they're an electrician, they're logging on over here. If they're a massage therapist, they're logging on over here. And so externally, we want our customers to have a single portal where they can interact with TDLR, just like they do today with their bank or Amazon or any other common internet service that they utilize. So internally, we're looking for increased efficiency. Externally, we're looking for improved customer service and how we represent TDLR to the public. Additionally, we had some basic high-level guiding project principles. First and foremost was that we need to make sure that the data that we're entrusted on behalf of citizens is secure. And so there's an explicit requirement in there, and DIR provides a number of security requirements in terms of, we affectionately call it TextRamp certification. Anything that we want to do that's internet or cloud-based has to meet TextRamp certain security requirements so that we know, and that data is always stored within the contiguous US. And so we own that data. The vendor never owns that data. We have control over that. We wanted it to be a flexible and configurable system, as I mentioned. So we want to get away from having to make as many coding changes as we do. We want the system to be configurable, is the word in IT today, so that it doesn't require tickets necessarily for somebody to do underwater welding, as I like to call it. We have people with deep skill sets, but there are a number of things that in modern systems that allow us to make changes, like should the agency reduce fees, that should be an easy change. And we bought an existing solution that makes that easy to do. On top of that, we had minimum qualifications for the vendors. Anyone that wanted to bid on this project, we required that they had at least 2 references and 2 projects they'd done for licensing systems of similar size and complexity within the United States. And that one of those had to be something that they had done in the last 5 years. And we wanted to do that so that we could know that they had a modern solution and that they had done the work recently, as well as we required them to provide 2 signed reference letters, as well as we verbally checked those references for the vendors in this process. Going through that, this is any procurement process this size in the state is a project in and of itself. This has been an ongoing effort that you guys have been aware of for some time. Probably it takes about a year to do this. The initial part of that was we did market analysis. And from day one, we hired a vendor to support, supplement, and complement TDLR's strengths with respect to this process. That vendor stayed with us from day one all the way through negotiations. So the entire process of everything we've done, once we developed the RFO that was submitted to the QAT team, as I previously mentioned, they reviewed that document before we posted it. After we posted it, the vendors had time to actually submit questions. We wrote back specific answers. All the information was publicly available on the ESBD website, which is the standard process for procurement this size. The vendors then generated responses. We had an evaluation team. That evaluation team was comprised of members across multiple divisions within TDLR, included IT, our security office, licensing, E&E. We did try to limit the responses. We specifically said you can't write more than 150 pages of narrative to try to make it a little bit easier on the evaluation team. In terms of when we specifically required them to provide a realistic time frame, budget, project, and to be succinct in their answers and their descriptions of their services and capabilities and the overall solution. The evaluation team scored those. We ended up doing vendor demonstrations. Those vendor demonstrations consumed about 45 calendar days. It took a tremendous effort to pull that off. We did them all here in this room. And so we asked vendors to come in and actually demonstrate their solutions, both functionally and technically, and provide us an overview of who they are and how they approach the project. It gave the evaluation team an opportunity to see what the vendor was going to bring to the table, rather than just reading on a piece of paper, but actually see the resources that we'd be working with. After that, the evaluation team had another opportunity to provide scoring. We moved on to what's called best and final offer. And after that down select, the evaluation team came back together and we did all the reference checks. And based upon all that information, we decided on ultimately who we should proceed with negotiations when we did that. And again, our contract vendor who was doing procurement support was with us through this entire process. We did negotiations. In fact, negotiations occurred in this room as well. We were able to knock the majority of those negotiations out in about the first 2 days. And it's been about another couple of weeks. Lawyers always make everything difficult. So making sure that whether it was the or the on any given page, we made sure that all those I's were dotted, those T's were crossed. And so today, what we're bringing to you, I think, as Charles had described, is basically seeking your approval on accepting that contract as presented and granting Courtney the authority to execute that contract.
Mr. Smith, may I add, during the negotiations, with absolute certainty, no issues were negotiated, compromised the agency's risk factors identified, we believe have been covered, and there was opportunity to interact with the CGI's legal team as well as members of the staff, and those negotiations were friendly and not contentious, and we were able to reach agreements on all the issues within a 2-week period.
Okay. Before we questions, commissioners, I want to make sure and give you this caveat. We don't want to talk names, vendors, to make sure that any details we need to keep limited to because we're still in the middle of a negotiation. So please do that. I'll open up the floor for questions.
Chair, I have questions.
Yes, sir.
How many vendors typically showed up on the solicitation, how do you all narrow it down to what it is? How many of them proposed? 30, 40 or something to,
We initially, the agency received 12 responses.
okay, and then the second phase was, what is that?
That was narrowed down to 8, and then 8 was narrowed down to, that 8 followed through with, all the way through demonstrations. And then from there, after the demonstrations, we narrowed it down to 3 for best and final offers. And so we requested best and final offers from 3 of those original 12.
So one other aspect is, if I look at it, it's a software, which is a purchase by the agency. Has the agency looked into outside, like for us testing? We have an outside contractor who does just the test, whatever it is, the student in order to get the license. Have we looked into outside the box? Rather than be owning the software, vendor owns their software, they charge each licensee X amount every time they license. Have we thought anything like that, or that's not the intention of the agency, that we need to own the software?
So what we specifically asked for in the RFO was a cloud-based software as a service type solution. And so in that instance, we are licensing the software to use. It's not ours to own necessarily, but we don't own the intellectual property of the solution.
Okay, I get it.
But we're going to lease it until we're ready to move on in 10 years or whatever for the next solution, whatever that is for the agency. So, and I will say that in our market analysis, we actually leveraged other contracts we have with vendors that provide market analysis. Licensing as a domain, as a business domain, is tracked. And there's probably 40 or 50 different vendors that provide all types of different solutions for different portions of the licensing domain. And so we did a lot of due diligence up front prior to releasing this to sort of see what would be the best solution for TDLR.
Okay. If you're looking at the software, and I'm assuming that there's a maintenance component added, right?
There's an annual cost in running and leasing the software, yes. A license cost, and then we included an option for maintenance in terms of additional support to make sure the transition for the agency, that as we continue to go live, that we have functional support from the vendor.
So in terms of the maintenance, is it annually decreasing, or it's going to remain a constant for the next, whatever the 4-year or 5-year period, what you're looking at?
So we asked for 5-year operating costs. The maintenance costs essentially remain level. The software costs go up because our deployments will not, eventually it essentially levels out, but because TDLR is always growing, we're always going to need more licensing because the licenses are based on activity. And we know that TDLR's activity continues to grow. And so there are 2 things about the license costs. You'll see throughout the project, they're going to increase because we're going to increase the number of programs and licensees that are now using the new system. So we start at a certain level. We add that as we roll on a new program like BARCAUSE. Now all of a sudden I'm going to need 300,000 licenses to support our BARCAUSE population. In the future, we know that if we bring on additional programs, like recently we brought on electric vehicle service stations, as we add those things, our license costs can go up.
So this maintenance does include the annual cost for licensing the software plus some support services. That's what I understand?
Yes, sir.
Okay.
That is correct.
The other question, Chair, I don't know, what are the implications of the staffing? Do we need more staff or less staff, or what's going to happen? Are we still
We
evaluating?
have staff currently involved in the different licensing system. As you know, multiple systems are being moved into one through this project. So while it's hard to say that it'll be a 1-for-1 change, we should have cost reductions from the cost of the existing systems that will now be spent on the long-term maintenance of this project. And some of the staff resources could be used differently when they're no longer supporting the existing systems. But to say it's a dollar for dollar change, we can't say that.
No, at this time, I think, there could be some staff relocations based on the efficiency of what we see. Fair enough?
Ideally, when you go with an off-the-shelf system, you are able to find some capacity in the way you were using staff.
And Commissioner, I think the question goes to one of the guiding principles that John referred to, is that the system we're looking for efficiencies. And that's one of the factors that was considered.
We were dozed before Doge was cool.
Yes.
Right. Right, Tom?
Yeah. One of us up here put the DOG in Doge. I'm not gonna tell you who, but, and so I'm gonna ask some questions. The last thing I want is the perception to be, because I'm asking questions, I have a problem. I have concerns because I care, right? And if I didn't care, I wouldn't ask any questions. So I want to preface what I'm about to say with that. And I think any reasonable person, when you're about to spend $40 million over 5 years, if you don't have a question, you're probably in the wrong place. And so in the consultation that you gave us a couple of days ago, I was really impressed with the presentation that you made, John. I'm going to ask you, I'm sorry if you'll bear with me, to please, in a minute or two, give us your resume, give us your background on projects such as this. Tell us what you've done. Why do you have the right to be at that table?
Okay.
He deserves it.
Not just because he's good looking.
Go ahead.
Tell my brother that.
You're just giving him energy. Answer the word.
I've been a public servant since 2004. I would say my biggest claim to fame is that I was responsible for the unemployment insurance systems for the state of Texas, particularly during the pandemic. And so that was a $4 billion a year system that I had a team that managed that went up to about $55 billion in a tune of about 12 to 18 months. But at the Texas Workforce Commission, oversaw a number of projects, one very similar in size and complexity to this one, and multiple others outside of the unemployment world with respect to that. Prior to that, I was in private industry. I worked for Accenture before they were Accenture, where I helped build the child support system that's still running today, at least part of it in the background. So I worked at a kid, and I don't know, I think some of y'all, I mean, when I was 12, I worked on my grandparents' farm to earn enough money to buy my first computer, which was a TI 99 4A. So, for those of you that are.
We don't want to go that far back.
But
Anyway, so that's good.
yeah, for mostly, I mean, I've been here a little over 3.5 years now. So prior to that, I was 17 years at the Texas Workforce Commission, managing and directing the application development services.
And when you looked at the potential out there, right, the whole universe of what we can do, y'all zeroed in on a couple of things. You zeroed in on Gardner. And why did y'all do that? What does Gardner provide in terms of licensing systems for you?
I'm going to say that slightly differently. Actually, Gartner has nothing to do with the actual solution in and of itself.
Okay.
Gartner is an advisory service that we subscribe to.
Okay, there you go.
And they provide things like market analysis.
Okay.
And so they're the company, I didn't mention by name previously, but I think that I can, because they have nothing to do with this procurement. So Gartner has market analysts, and they do nothing but study specific areas. One of those areas is licensing as a domain. I think they call it community development. And so they look at a broad range across possibly the world, certainly within America, a number of entities, vendors that provide solutions in this market space. Now, some of those vendors are dedicated to very specific or niche functions, right? Maybe like tax permitting or something like that for local jurisdiction.
Sure.
And so they track about 40 or 50 vendors in this market space. So we actually met with the authors of their market analysis prior to this procurement. We met with those vendors. We met with other state agencies within Texas that perform licensing functions. We met with the Alcoholic Beverage Commission, DPS, does driver's licenses, DMV, motor vehicle registration, the Real Estate Commission. Similarly, we reached out to use some of our common relationships through DIR and got connected with Arizona. They have an entity like DIR, met with who's doing a statewide licensing system, met with our sister agency in Washington, Wisconsin, Missouri, and Florida to find out. And of course, we just commiserate, right? We find that we discuss the challenges to licensing and regulation and find out what solutions they're doing and how they were pursuing their modernization efforts or what they had done to modernize. So we did a tremendous amount of upfront work, and explicitly we hired Gartner to actually perform that market analysis, where they took some of TDLR's high level information and sent it out to vendors and said, tell us what it would take to build a solution for TDLR. And we did that to help confirm sort of scope, functionality, and budget. And there were 3 lessons learned
out of the prior attempt, roughly 6, 8, 10 years ago now, that was called TLS in terms of one, we want an existing solution. We didn't want to reinvent the wheel. Two, we wanted a vendor with demonstrable success. And so not only did we require that as a minimum qualification, they also had to submit the 2 signed reference letters, and we verbally confirmed those. 3, we actually asked them to, and then we asked them to come in and demonstrate their capabilities. And then the third thing was make sure that we were appropriately funded. And we know the commission was crucial in helping us obtain the funding in the legislative session. And so with those 3 things, and we've actually demonstrated small successes on those lessons learned. This agency I mentioned, we have multiple disparate systems. A couple of those systems we inherited from other agencies were on old antiquated technologies. And over the last 2 years, we've gone from 9 down to 7 because we've actually moved a couple of those systems to Versa, which is a slightly more modern system that we have. And so we've been able to demonstrate we learned from our mistakes, and we've demonstrated success in a small manner. And the goal of this project is to continue and move forward, divide this work up into small manageable chunks, just like we did, and keep moving towards a modern singular solution. So you just mentioned inheriting systems from the conglomeration that we are now.
All the legacies.
Could you give us about a minute or two? What is that? What does that mean? You have 8 systems. I know what it means. I've been here a long time, right?
Yep.
So, I mean, the story is
when Charles was talking, I'm going back to Ronald Reagan's line when he was when Walter Mondale said he was too old to run. And Reagan said, I'm not going to make age a factor in this discussion. I will not hold my opponent's youth and inexperience against him. People like Charles and I with the gray hair.
Well, I'm asking, how did I fit into this?
It brings back, I think what he's saying is in the condition, the legacies that we've aggregated over the time, is the legislature has given us.
What does that look like? I'll tell you what that looks like. So, yeah, I mean, I've completely fabricated this story, but I've told it to every vendor that'll listen to me. I assume 75 years ago, a podiatrist was elected to the legislature and said, we need to license podiatrists. And they created the podiatry board. That was in existence for about 60 some odd years. And about 10, 12 years ago, they said, why do we have 2 dudes and a lady in a closet over in this one building who do nothing but license podiatrists? We should give that to TDLR. And when they did, TDLR said, we'll take that on. Absolutely. We can do this. This is what we do. And so when they moved that system over here, rather than actually converting the data from their podiatry board system, this agency just said, we'll just run it. And so what we ended up being stuck with every time this happened was we had our basic system, which is Tulip. It maintains about 80% of our data. But then we brought over a podiatry system. And that system did licensing, did everything Tulip did, but only for podiatrists. And then we did the same thing when we moved over a couple of systems from DPS that involved driver education and motorcycle training. So we had 2 more systems. All they did with those specific things. But now every time you wanted to do something, and they all do them slightly differently. They're different technologies. So now I have to have an IT. I need somebody with a different, you may be an underwater welder. You can support that system, but I need somebody else with a different skill set somewhere else to keep that one system going. And podiatry is a great example because we were having to pay a lot of money to support a system that probably supports maybe 1,300 licenses, but an entire system that I have to keep up, maintain. And Commissioner Droxaram is always giving me a hard time about our server upgrade process. And we had worked ourselves into scenarios where we couldn't upgrade our server because the solution that we inherited wouldn't run on a more modern version of the server. So many questions come to mind. The first thing I'm going to say is, what a testament to our agency that the legislature keeps giving us different programs and knowing without any consideration to the licensing requirements of that, they just say, take this agency on now. We have 1,300 podiatrists, maintain the software that it takes to license them. There's no money involved, but we want you to do it. And so we have 8 different licensing programs, 1,300 of them are feet, right? And now we have to put it together. And so that's the rationale for this expense, correct? It's a big part of it. We can't maintain, essentially our primary system, for all intents and purposes, a mainframe system. Right. It's difficult to maintain on the technical side, and it's difficult it's hard to hire people and want to make it attractive to say, come work here on this system. Oh, you need to go to the 15 screen to update that address. Right. I mean, there's no point, there's very limited point and click. And so, yeah, I mean,
the cost to train people both technically and functionally just on our primary system is exorbitant.
Okay. So that's kind of the rationale for it. And I see it now so much clearer than I did.
Yeah.
And so thank y'all and your team for that. The second part that overwhelmed me was just on the state side. What hurdles do you have to go through on a contract this big? On this, whose sign off or buy off do you have to get? Can we talk about that just a little bit?
So
Because that was overwhelming.
in my opening comments, so this is considered a MERP, a major information resource project. So there's state requirements in terms of creating a business case. Initially, that's reviewed by QAT, which is this quality assurance team, which are individuals that work at multiple different agencies. Before you can publish the RFO, it has to also be reviewed by a comptroller advisory team. And their roles, basically, all of their roles are to make sure that we're following best practices. CPA produces a procurement guide, and we have a procurement team and a general counsel team. And we're talking about thousands of hours invested to the point where we are today, right? This is a huge team effort. And
so the QAT, then the comptroller's office.
Yep, which that was called CAT for Comptroller Advisory Team.
Okay.
And so they review it before you publish it.
Okay.
QAT reviews the business case. CAT reviews the contract before you ever publish it. And then once you publish it, once you finalize negotiations, you submit the final contract back to QAT for their final review. And both of those processes, what they're looking for is making sure that you're following state procurement guide, best practices, and that we're focused on finding the best value for the state of Texas TDOR.
Okay. That's not all. DIR?
Well, DIR is part of the QAT. Okay. QAT is comprised of DIR, Legislative Budget Board, Comptroller, State Auditor's Office.
Okay, so you
I think I have
2 meetings with them, one up front and one after the contract. Yep. Okay. And in between, you have the comptroller.
Yep.
So there's a separate set of eyes saying the need exists in the business case.
Yep.
And then the second set of eyes on the comptroller saying it doesn't look like money's being wasted here.
Right.
And then once the contract is negotiated, it goes back to the QAT and say, yes, this comports with the case that you gave us in the beginning, and it does address those needs. Correct? So that they're not hoodwinked in any way.
Agreed.
Right. I got you. Okay.
Commissioner, to add to that discussion, the CAT team had a few recommended suggestions, recommended changes to the documents.
So they have inputs.
Yes,
They
sir.
have some say.
And
Okay.
we took those comments and incorporated them into the solicitation before it was issued.
Okay.
And once they went to the QAT team, a final review of the contract, the proposals, and then so forth, they came back 0 recommendations. And
Fantastic.
so that puts us here today in this meeting, for your approval.
Okay. So so the business case exists for it with 8 disparate agencies. What happens if we get another one in a year or this legislative session? Is the final product going to allow incorporation into that, or what do you anticipate? I know you had to think about it. You've thought of everything else.
Yeah, and if I didn't say that enough, I'll say it again in my opening remarks. We absolutely said, the RFO has indicated, we know one thing, there'll be change.
There'll be change.
So this system has to be flexible enough to either incorporate new programs, new licenses, changes in the rules or regulations around our existing licenses. We want that to be faster and smoother. We required other things, seamless integration. We use Texas.gov for our payment processing. So we want seamless integration with those services that we use. And so all of that was incorporated in the RFO.
So you anticipated my next question, the payments. We've had problems, right? Some of our programs still accept checks.
Yeah.
Right? The federal government said they want to phase out checks in the next year. So you're anticipating those.
Yes.
Okay.
Yep. Our goal today, roughly 90% of our business is done online. But that 10% is what eats our lunch. And so we've got to address that 10% and figure out from a manual perspective. And once you start doing that, then you can figure out how to realign your resources with other agency needs. But until we get there, we won't be able to do that. But yes.
And a lot of this is just preparation for really the big show, and that's implementation.
Absolutely.
Right? And Charles isn't going to be there to help you then. He's
Nope.
going to go, I don't know what you're talking about. This computer's
He says he wants to be involved. We're trying to figure out how to.
Actually, this is a point of lessons learned, as to when you release from the project. If we haven't engaged, I think, longer in the earlier projects, I think, we may have had a different result. And so John's correct, at some point, we step out of this process, but the question becomes the timing.
And let me just add to that in terms of oversight. Another standard practice of any project of this size, we will be hiring an organization to perform independent validation and verification, like an auditor. They're gonna be here as soon as we can get them on board. And their job is to really report to Courtney and to say, here's what you're doing right, and here's what you're doing wrong, and here's what the vendor's doing right, and here's what the vendor's doing wrong. And so,
Would we have a chance to talk to them under the audit work group? If they are an audit function?
yeah.
Okay, so that they can come to us directly too? Would that be okay?
We'll probably,
That I don't
I'll
know.
probably put together an implementation committee.
Oh, okay.
So that may be, that probably, well, throw on an audit, right?
Okay.
We may have an implementation where we have oversight from the commission level.
Okay, that's a great
We
point.
will absolutely find the right cadence and mechanism for reporting all project activities to you.
And I think that we should be careful as to how those discussions take place in public, because there could be a contract dispute, and we want to be able to maintain that information close. And they're not discussing it in open meeting.
Always doing your job.
Thank you, Charles. So one of the things about this agency is that it's always been very transparent. Doug mentioned that earlier today. It's one of the core values that we operate by. We've had, again, not to beat up on anybody, because it's all us, ultimately, those that sit at this table, whose responsibility is the wins and the losses, right? We rely on y'all for the wins, we own the losses. So, you know, we wasted money in the past. It was a small amount. And that's, so a lot of this fear is born from that failure. Okay, we'll own the failure, but we want to make sure we don't do it again. And that's why the purpose of these questions. And y'all have done a great job of insulating and protecting us, because we did have to cancel the earlier solicitation because things just were not right. And we were able to catch it and stop it, right? And we addressed it midstream. And so congratulations, everybody, for doing that, because realizing this is not right, we're going to stop it. We policed ourselves. And that's exactly what we want to do, right? We want to be in the business of saying, this is not proper path. We'll stop it right here and start from scratch if we have to. I think that's an incredible way to live your life, right? Because I wasn't sure until your presentation the other day. Y'all have satisfied a lot of concerns and fears that I had, quite frankly, because we're an incredible agency. You go to the Capitol, they can't help but talk about us and how wonderful a job we've done. And, you know, y'all don't get to see it many times, but we hear it every day that we're there, right? They are impressed with what we do. So y'all make us look good, and that's hard to do, right? And so I
should
think
agree with that.
I'm speaking for myself only. So thank you. You, like I said, you satiated a lot of the concerns that I had. So let your team know if they're listening. Thank you so much for what you've done. Charles, your team as well. We've got two journeymen at the helm here. And that gives me a lot of peace. But the hard part's about to start.
The hard part is now we're enough for both of us, trust me.
Any other questions? Commissioners on screen? All right.
I have a question.
Yes.
Sure. I think they briefed pretty good on Monday. We had pretty good lengthy discussions. I can't argue with Charles on whatever on the legal stuff. And John, I have confidence. I think you asked his credentials. I think, speaks of himself of what he has done in the past, no doubt about it, the project, like the last time, it won't be done. I had a couple of more questions on Monday. I sent an email. Staff were trying to reach me on Tuesday. I was traveling, didn't have any information. If you want to move forward, I'm going to make my decision based on what it is, or you want to allow me to discuss with them, I'm open with that too, but either way, I'm fine.
Thank you. Thank you for saying it. Any other? Callis, you're speaking, but you're not. You're on mute.
I was answering about bare knuckles by the governor's office. I was talking on my phone for a second. Sorry.
Okay.
But I
didn't
do,
get a question.
hey, now if the other commissioners are done asking a bunch of questions, I would like to make a motion.
Oh, can I say one more thing?
Yeah,
One more
please, go
thing.
ahead. We got all the time in the world, sir.
It's a little early, it's his birthday, Liz, give him a little something. Go ahead.
I failed to thank the executive staff as well. Courtney, you and your staff, of letting Charles and John do what they need to do. Picking them to head this up, was a masterful stroke. And so I applaud you for that. Good job. 11 months into your job, this is where we're at, and that's incredible. This speaks to wonderful things, I think, under your tenure and tutelage. So thank you.
Dr. Callis? Dr. Callis? You got a motion? You're on mute.
I am. Is it okay now? I would like to make a motion that without saying the actual vendor, without getting into person, place, time, I would like to.
Hang on, Dr. Callis, just yet, we're gonna read the motion. I think Doug has a formal reading of that motion.
That's
Give me a
fine.
second and you can.
That's
Amen.
fine.
Okay.
No problem.
Great. Got everybody on camera too. All right, so assuming this is the direction you want to go, Dr. Callis, and please let me know. I'll give you I'll answer any questions you have. The motion would be to accept the department's recommendation to contract with the selected vendor for implementation and maintenance of the legacy systems replacement project, to authorize the department to make non-substantive edits and finalize the contract, and delegate authority to the executive director to sign the contract documents.
Good. Are you agree with that, Dr. Callis?
Yes, I totally agree with that statement.
Is there a second?
I'll second it.
Dr. All in favor, say aye.
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 Aye. Opposed?
Me,
No. Okay. Ayes have it. Motion carries. You have your.
And Commissioner, with that vote, we anticipate a contract signature by mid next week. And at that point, the documents will become public.
Perfect. Commissioner, I'll probably consider putting that committee together. If you're interested, again, let me know. And I want to make sure you guys I don't draft people into this. This is going to be a lot of work. So I'll get with Courtney on what the details of that committee would be. Okay? Make sense?
Yes. Would like to make one suggestion if we could. Because Commissioner Droxaram does have some concerns about the way this has gone. I'd like to ask you to serve on that committee.
Okay.
I'd like you to chair that committee.
no.
You have that authority. Once again,
Just think I'd like him to.
stay in your lane.
Just think I'd like him to.
Thank you. I appreciate that. All right. Thank you, gentlemen.
Thank you.
Thank you for your efforts. Tell your team thank you and outstanding job. Please.
Great job. Great job.
Item H, Sharon?
Oh, I can jump in first.
Okay, sorry. All right, I'm sorry. Actually, Sharon, this is June. This is Doug. I apologize.
Well, it's kind of a group effort, but I can lead us off if you don't mind.
You bet.
And I'll do it from this seat since I think Janie and Sharon will be taking it.
Okay.
This next item is discussion and possible action to approve changes to the department's personnel manual, implementing Governor Abbott's executive order number GA 48. Again, for the record, Doug Jennings, General Counsel. The executive order GA 48 was issued by Governor Abbott on November 19th of last year. And it directs state agencies to make efforts to protect critical infrastructure from foreign adversaries. And so some of the provisions some of the executive order require state agencies to amend their contracts and contract policies, their contract procedures, and ethics and personnel policies. The notable things we'll be talking about today are prohibiting employees from accepting gifts from those foreign adversaries. The short list I'll give you is China, North Korea, Iran, Cuba, and the president of Venezuela. But prohibit employees from accepting gifts from those adversaries, requiring changes to the personnel policy to allow employees a method to report violations of employees who accept gifts from those adversaries, and to provide regular reviews of certain types of employees, state employees, to ensure that they don't have a connection to those foreign adversaries. That's the very high level. And then I'll ask Sharon and Janie Weber to walk through the proposed language with you for your approval. Thank you.
Thank you, Doug. Sharon Hamoya, Director of Human Resources, PBLR. The information that was sent to y'all was related to change the personnel manual in section T of the hiring and job posting procedures and criminal history record checks for IT candidate, technology candidate, sorry, IT candidates and employees. It would be the addition of, in the policy of a cyber intelligence review. This would impact staff that are in the information security office as well as the information technology services section. And what was sent to y'all was recommending a 3-year on hiring and every 3 years or after for employees in these sections. But the commission work group met on Friday, April 4th, and recommended that be changed to 2 years. And so it would be on hire and then every 2 years thereafter. The cyber intelligence reviews DPS has been instructed in the GA 48 to contract with a company to provide those intelligence reviews, and then HR would administer them. But the language in the policy would allow for that to happen for those particular staff.
Janie, you have any?
Yes, good morning. My name is Janie Weber. I'm the Assistant General Counsel within OGC. And I'm also going to be speaking to amendments to the personnel policy, specifically the ethics policy, which you can find under section 11 of our personnel manual TDLR. And when we made these revisions, we wanted to make very certain that we mirrored the language from Executive Order 48. And so if you look at the actual language, it speaks to how the executive order was issued, a specific date, and that the aim of the policy is to safeguard the health, safety, and welfare of Texans by protecting critical infrastructure from foreign adversaries. And again, that's language that is from the executive order. We go on to say, in accordance with GA 48, TDLR employees may not travel to or accept any gift from an entity on or associated with the U.S. Department of Commerce's foreign adversaries list. Now, if you'd like to go and look at that list, I can tell you that that list lives in 15 CFR section 791.4 in the federal regulations. However, we did not cite to that. We also did not do a laundry list in our policy simply because on a practical standpoint, we don't know when it is that's going to change. And, from a practical standpoint, my understanding is the plan is that additional type of information or changes to the policy, if it happens, by the feds, is going to live on our LRNet, specifically the general counsel section of the LRNet, so that employees can receive up to the minute guidance as needed. And that is a project that is TBD. We go on to say that a violation of this policy will result in disciplinary action up to and including termination in accordance with Section 10, professionalism and disciplinary action policy. Now, that was not in the executive order, but that, of course, will encourage compliance by our employees to have that extra layer of enforcement included in the policy. We go on to state, if an employee is approached by a foreign adversary or an entity associated with a foreign adversary with an offer of a gift or travel, the employee must report the incident through the Office of General Counsel's LRNet page. We go on to say, additional information on Executive Order GA 48, including information of the reporting process and commonly asked questions may be found on the Office of the General Counsel's LRNet page. So that ends the employee ethics section of the implementation efforts for GA 48.
Excellent. Questions, commissioners?
Chair, I have a question for Sharon. This 3 years that's what it shows, that's 2 years right now? You'll come up,
The recommendation was to change it to 2 years from
is
the
it calendar year or the higher time?
based on the hiring date or the first implementation. So employees that are currently hired, it would happen when
The anniversary?
Yes.
Okay,
yes, sir.
not the calendar. Okay, thank you.
Yes, sir.
Anything else?
We are asking for a motion to approve the
So
changes.
moved.
Is there a second?
Question real quick.
Oh,
Yes, sir.
Is there, it's okay. Is there a way, I don't want our employees caught unaware. Is there a reminder or a tickler or something that comes up that says, every 2 years that, is there an attestation or something?
Well, so just like what we're doing with the criminal history reviews, we send those out, we ask the employee to complete a form, and so they're aware that we're actually running the review prior to it happening. It just doesn't happen
Just remind.
without their notice. So they are aware, and we're in contact and communication with staff.
Fantastic, thank you.
So-
any other questions before Dr. Strong's motion?
Wait. Janie, was that a bacon shift? You were.
Oh, no, sir.
I was gonna say, did you bring it up for everybody?
Oh, no, my apologies. That was, I
I'm sorry,
brought some.
Jane, you don't have to. Commissioner, you have a motion?
Yes.
Is there a second?
Second.
Thank you. All in favor, say aye.
Aye.
Opposed? Opposed? All right, motion carries.
Sorry, Janie.
You bet.
All right. Contested cases, commissioners, we're going to item I. We're gonna adjust one of our cases to bring it to the front. Jessica Tato. I'm gonna get you to do both your same time that you up here instead of coming back, okay, if you don't mind. And then we have Ms. Lowe. Did I pronounce that right? Yes, come on up. And do we have an interpreter?
Yes, I believe Ms. Dobson is gonna provide the, yes, there she is, is going to
You can,
provide
you
some
can welcome to
translation.
sit next to your wife if you like, but you weren't at the SOA hearing. Our attorneys are gonna probably object to anything you have to say, but you're welcome to sit next to her if you like.
Okay.
Commissioners, we're gonna be working through an interpreter, so when you speak, please, allow time to for translation.
Ms. Dobson may be waiting, to get the, translator on the line. I can go check.
She's right, yeah, she's.
She's right there. She's good. We'll give her. a
Okay,
second.
gotcha.
We'll give her a second.
Yeah, she can continue, right?
I don't want to say anything in this case until we have an interpreter. She's charged.
What's on chips? You got your bag? Right there.
Chairman, the alternative, we could hear Ms. Hurtado's other case, while we're waiting
Is
translation.
there a respondent to that? I don't think there is. No, there's not.
I don't believe so, unless Mr. Riles.
Would you want to do that? This is your interpreter.
Here she is.
Okay.
Ms. Dobson, are you ready to go?
Yes.
Okay, here we go. She's got language.
Ms. Dobson?
Yes.
Okay, can you sit next to the, on it, or you have a,
Yeah, I have the language line, so I'm just going to in here.
you're gonna have to explain to me how this works. Do I talk to the phone or do I talk to?
Yes, this is a language lines that like we have a over the phone interpreter. So the person will be translate English to Mandarin and then.
Okay, okay, why don't you sit next to her so she can make sure she, and when a commissioner speaks, she's automatically communicating to Ms. Love, right?
Yes,
Correct?
yes.
Okay, so I can start the conversation now.
Can I inform the?
Yes, please, please.
Thank you. Hello, are you ready?
You comfortable? All right.
Okay, so I'm going to translate from English to Mandarin. Ready?
Would you communicate to Ms. Lowe to let her know that this is going to be her? Okay.
你好，
您好，我是您今天的普通话翻译，我很荣幸为您服务。本次通话可能会由于培训或者质量保障的原因被监听。
啊，好的，谢谢，我是罗慧红，很高兴能有你的帮助，感谢。
You ready?
不用谢。
Yeah, I'm ready.
Okay, I'm gonna read some instructions to you, and then we'll start. These instructions are gonna be, we'll hear from the prosecutor first, and then we'll hear from you. You'll have an opportunity to speak. Make sure you speak clearly and say your name and who you represent. Each side will have 5 minutes to speak with up to a 3-minute rebuttal if needed. Please understand that the commission can only hear, this is important, can only hear information that was court record in the case at the SOA hearing. So you must limit your comments to those matters that were present in the SOA meeting.
This is the interpreter speaking. I apologize, but is this a legal case?
Yes, this is commissioner's hearing.
This is the interpreter speaking. I apologize, but I'm not specialized in the legal area. To ensure the best quality, please allow me to connect you to an interpreter that is specialized in the legal services. Is that okay?
Okay. Do me a favor. Why don't you go ahead and connect with her. Ms. Lowe, I'm gonna ask you to just sit for a minute, go back and down, sit, and we're gonna go through one more case, and I'll ask you to come back, okay? If you don't mind. Thank you. Let's go. Or Jessica, can we go to item, Commissioner, we're gonna go to item 4. Malcolm Riles, you mind to jump on that one? Okay.
Yes, good morning, Commissioners, Chairman. My name is Jessica Hurtado, and I'm a prosecutor in the Enforcement Division. The ALJ recommends that you deny Malcolm Rouse's application for a Class A barber license based on his criminal history. And I ask that you adopt the PFD as written. In 2019, the applicant was convicted of sexual assault of a child, a felony offense, and sentenced to 2 years in prison. The applicant on multiple occasions performed oral sex on the victim, his 16-year-old nephew. He was 38 years old when the offense occurred. The applicant submitted a criminal history questionnaire to the department where he wrote, quote, "I was accused of a crime I did not commit." At the hearing, the applicant testified that he completed his prison sentence and would like an opportunity to prove himself as a barber. Additionally, the applicant had several friends and family members testify on his behalf and provide letters of recommendation from 4 additional individuals. Crimes involving prohibited sexual conduct or involving children as victims are guideline crimes for barbers. As a licensed barber, the applicant would have direct contact with members of the public, including children and teenagers. Additionally, if licensed as a barber, the applicant would be eligible to teach barbering services as an instructor, potentially to minor students. If granted a license, the applicant will have the opportunity to repeat the prohibited conduct. In analyzing the Chapter 53 factors, the ALJ notes that the applicant's offense is a serious felony that occurred when the applicant was a grown adult. Further, it has been 6 years since the offense occurred and only 3 years since the applicant was released from prison in July 2021. While Mr. Rouse successfully completed his barbering education, he presented no evidence concerning his work activity before or after his criminal offense. Regarding his rehabilitative efforts, the ALJ notes that the applicant has not taken responsibility for his actions, nor has he provided evidence that he participated in any rehabilitative efforts, either while incarcerated or since being released. Finally, the ALJ notes that while the letters of recommendation and witness testimony address his barbering skills, leadership, and work ethic, they did not address concerns raised by his offense or the possibility that he could reoffend. Therefore, the ALJ concludes that the factors weigh against licensure at this time. The ALJ recommends that you deny Mr. Riles' application for a Class A barber license. I ask you adopt the PFD as written, and I'm available to answer your questions. Thank you.
Any questions?
Mr. Chair.
Yes, sir.
Hold on.
Yes.
Just let Dallas make a motion.
Oh, I'm sorry.
That's his birthday.
I was just gonna make a motion to support the PFD.
All right, I'll let you second it.
I'll second that.
All in favor, say aye. Opposed? Motion carried. Thank you. I'm gonna have you stand by.
Okay.
I'm not sure we're gonna bring this
Chairman?
on just yet.
We cannot adopt the ALJ's recommendation in our procedures unless we have heard from the respondent. They're present.
Oh, they're present.
It's a different case.
It's a different case.
I'm so sorry. I
It's
thought
Mr.
we had
Riles.
moved on to, my
Yes.
apologies.
Yes. Yes, thank you, Council.
Yep.
Having a good time today here. All right,
Yeah.
can you stand by?
Yes.
Just give me a second. I'm gonna, yeah, I know, I got you, Ray. I need to talk with them. I'll have some staff talk with them directly before you make your offer. I'll make sure that's fair. So while that happens, we'll have Ms. Olera. We'll go to item 1, Commissioners. Doug, can you give her a second?
Yes, sir.
So just give me 1 second.
You're so sweet.
Josh, you up for your cybersecurity check?
Yes.
Yeah, make sure he follows all the rules.
All right. Where you have the floor.
This will be for Thomas Allen Maniscalco Jr. Good morning, Chairman and Commissioners. My name is Natalie Olvera. I'm a prosecutor in the Enforcement Division. The ALJ recommends you deny Mr. Maniscalco's license application for cosmetology operator license based on his criminal history. I ask you adopt the PFD with one technical change. Conclusion of law number 11 cited a previous version of Texas Occupation Code statute that's cited in there. I asked it reflect the current language of that statute. In May 2021, Mr. Maniscalco was convicted of the felony offense of online solicitation of a minor. He was sentenced to a 2-year prison sentence. Applicant's felony offense of online solicitation of a minor is a guideline crime for cosmetologists. Licensees have direct contact with the public and often in settings with no one else present. Additionally, a person with a predisposition for crimes involving prohibited sexual conduct or crimes involving children would have the opportunity to engage in further similar conduct in a salon setting. Applicant's felony offense occurred when he was about 33 years old, and applicant was about 35 years old when he was convicted. Applicant sent a message on Grindr to someone who has later identified themselves as 14-year-old within the first few messages. Applicant continued to message this 14-year-old and told the teen he wanted to perform sexual acts on them, such as, "I want to blow you." Applicant then proceeded to ask the teen if they had any friends who also wanted applicant to perform sexual acts on them by messaging the teen, "Do you have any friends that want some head too?" The teen, who was an undercover officer performing a sting operation, provided the username of another undercover officer. Applicant then sent a picture of his genitals to both teen/undercover officers and said he was on his way to meet them so he could perform the sexual acts they had discussed. Once applicant arrived at the agreed upon residential address, applicant was taken into custody. Applicant is currently registered as a sex offender. His projected release date is not until 2033. As for accountability, applicant stated law enforcement set him up. He also testified when he set up his Grindr profile to say that he was 19 years old when he was actually 33 years old. The conversation with the teen/undercover officers went on for about 4 to 5 hours, and he did not believe the conversation he was engaging in was illegal. While incarcerated, applicant stated he took several courses, such as Bible studies, anger management classes, and self-help programs, but no rehabilitation programs that directly related to his offense. He also submitted 2 letters of support, one from his husband and one from his mother. Applicant testified he was released from prison in May 2023, and he continued to perform cosmetology work after his license had already been revoked by operation of law due to his incarceration. Applicant was providing unlicensed services at that time. While his conviction did occur in 2021 and applicant was released from incarceration in May 2023, there has not been enough time to demonstrate applicant has been fully rehabilitated. I ask the commission again, adopt the PFD with the one technical correction and deny applicant's license application for a cosmetology operator license based on his criminal history. I'm available to answer any questions.
Thank you. Is there any questions? I'll take a motion.
Yeah, this is not good. I'll make the motion that we adopt the PFD
With technical.
with the technical correction.
Is there a second?
Second.
All in favor, say aye. Aye. Opposed? All right. Thank you, Ms. O'Leary. Thank you.
I'll do the next case.
Oh, what's this, Ms. Marple? I guess?
Yes.
Okay. Go ahead. You have the floor, go ahead.
Natalie Olvera, Enforcement Division. Cynthia Marple handled this case, but I'll be presenting it today. The ALJ recommends a $3,000 administrative penalty. I ask that you adopt the PFD as written and impose a $3,000 penalty. A partial summary disposition was issued before the SOA hearing occurred. The summary disposition found respondent violated the Texas Occupation Code by failing to obtain a permit in a timely manner. The summary disposition also found respondent waited approximately 8 months to apply for and obtain a required permit. Those facts cannot be argued here today. As a result, the SOA hearing and what is in controversy today is determining what amount of administrative penalty is appropriate. To determine the appropriate amount, the ALJ considered the following 5 factors: the seriousness of the violation, respondent's prior history of previous violations, the amount necessary to deter a future violation, efforts made by respondent to correct the violation, and any other matter that justice may require. Not obtaining a permit in a timely manner is a serious violation. Permits are an important aspect of the department's goal to protect the public because they help ensure the work is done properly. Failing to get an appropriate permit may present safety concerns for the public. Permits trigger inspections, which ensure proper installation. Respondent, as a licensed air conditioning and refrigeration contractor, should have been aware of the requirement to get a permit in a timely manner. Respondent's prior enforcement history includes a 2021 warning letter, also for failing to obtain a permit in a timely manner. A high penalty amount is necessary to deter future violations from respondent. While respondent ultimately did file for a permit in this case, respondent lied to the department's investigator. Respondent told the department investigator a permit had already been obtained in this case, but the permit was not actually obtained until after communicating with the investigator, and the respondent was notified about the complaint. The 8-month delay in applying for the permit and the fact that the permit application was done after the department contacted the respondent about the complaint shows that there was insufficient effort made by the respondent to correct the violation. Respondent argued that the COVID pandemic should excuse his violation. The ALJ did not agree that an 8-month delay was reasonable even during the COVID pandemic. Failing to obtain a permit as required is a Class B violation in the enforcement plan penalty matrix with a penalty range of $1,000 to $3,500, can also include up to a 1-year full suspension. Department agrees with the ALJ's analysis that a $3,000 penalty is appropriate for this case and these facts. Department requests you adopt the PFT as written and impose a $3,000 administrative penalty. I'm available to answer any questions.
Thank you, ma'am. Any questions, commissioners?
Yes, sir. Chair.
Yes, sir.
Council, the maximum penalty can be 3,500?
Yes.
Okay.
Is there a motion?
I move a motion to adopt PFT as requested with 3,500 as a penalty.
Is there a second to that?
I'll second
Second.
Okay. All in favor, say aye.
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 Opposed? All right, motion carried. Thank you. We ready? Okay.
I'll put it in.
All right. Ms. Lowe? Yes. Jessica, you ready? Are we ready for it now?
Yes, sir.
Okay. Jessica. Commissioners, and this next case, make sure we have a lot of latitude again, speak slowly, and I'll allow Bentley to play on.
Yes, Chairman, and Doug Jennings, General Counsel. I'll just ask, for the record, we've spoke with the respondent. It was our understanding that she would be providing her own translator today, and that was a miscommunication. We subscribe, the agency subscribes to the Language Line product, where we provide translation services through that from a neutral party. And we had the respondent speak to the translator back and forth, and she represented us. She is comfortable with the translation service provided, and she would like to proceed today with the case. And so just as a matter of course, to make things easier for the translator, if you have questions, please make them short and just give a little time, a little pause for that translation to come through.
All right.
Thank you.
Okay. Is translator on the line?
Yes.
Okay. All right, I'm going to read some instructions to you, allow you to hear them back, and then we're going to proceed with her. We'll hear from the prosecutor first, and then we'll hear from the respondent. You'll have the opportunity to speak. Make sure you speak clearly, say your name and who you represent. Each side will have 5 minutes to speak with up to 3 minutes for rebuttal if needed.
This is Cobra speaking. Is there any way you speak one sentence at a time? Is that okay, please, for accuracy reasons? As slowly as possible, please.
Interpreter requesting 1 or 2 sentences at a time.
Okay. All right, let me break it down again. All right. We will hear from the prosecutor first, and then we'll hear from you and you will have opportunity to speak.
我们首先要听，监察官发言，然后听你发言，你有机会发言。
好的，谢谢。
Make sure you speak clearly. Make sure you speak clearly, say your name and who you represent. Each side will have 5 minutes to speak with up to 3 minutes of rebuttal if needed.
This interpreter speaking with 3 minutes, what, if needed?
5 minutes to speak with 3 minutes rebuttal if needed.
Sorry, the line cut off a little bit. 5 minutes to speak and what?
3 minutes for rebuttal if needed.
好的，您要知道，您说的要非常的清，要说出您的名字，您代表的是谁？您各方有5分钟发言，如果有需要的话，3分钟来总结。
好的。
Last instructions here.
Okay.
Please understand that the commission can only consider information that is in the record from the case at the SOA hearing.
Interpreter.
This interpreter, again, please.
What'd she say?
She's requesting, repeat.
Repeat. Please understand that the commission can only consider information that is in the record from the SOA hearing.
您要知道，您要理解，这个委员会只会考虑在记录了听证会记录了的里面的信息。
好的。
OK。
Chairman, Doug Jennings, General Counsel. If you don't believe this setup is working adequately, what we can do.
That's to say the least.
Yes, I understand your frustration. And so, if we could have a few minutes, we could perhaps inquire if the language line representative could join us on WebEx. If that's not an option, if you're not satisfied with this proceeding, I would just recommend that we continue it to the next meeting and provide an in-person translator, either of the respondents that the respondent provides, or we can.
Okay, let me do this. I'll tell you what, commissioners, ma'am, just stand by for a minute. How do you want to proceed? Do you want to do a continuance, or do you want to just a question?
How far do they have to drive to be here today?
Beaumont. Okay, commissioners, just something to consider. Do you want to continuance on this, or do we want to?
Let's wrap it up if we can.
Okay. How about you?
6 hours, long way.
Okay, you?
I'm okay.
Okay, so why don't we take time out, let's see if we can get on WebEx.
Okay.
And then we can go from there. Will you explain that to me? Thank you. Jessica, hang on, I'll get right to you. Right.
Just
Ms. Gold, can you give me 1 more minute? We're gonna try to.
All right, I do not have.
She might not be capable, hang on, Jessica, she might not be capable of doing it.
The interpreter just report that only can do audio, unfortunately.
WebEx also can do audio.
It's just
We
phone call.
can connect you to the WebEx.
Council, how did this happen in the SOA hearing?
SOA has their own interpreter.
Yes, and then interpreter be able to be like.
We can't provide ours because we're biased, so we can give her, she has one of her own.
We have a staff member that volunteered to be an in-person translator. My concerns are simply that because this is a department employee, there might be a perception of bias. I don't think that would actually happen, but we have to be aware of it.
No, I'm fully aware.
And an independent translator is
Council,
always.
if there is a waiver right there, if the defendant doesn't have any issue with the translator, give her a choice right there. It may be a lot easier for her. If she's aware that department and she waives it.
Well, it's up to her.
Yeah.
Another interpreter level 5 who is core certified be able to join via WebEx as well.
So they're gonna be able to join.
We have a translator service that can provide video, apparently.
Yes.
So we would just need to connect them.
Yes.
Okay, we do have that. We will work on that.
One more time. Okay. One more time. Why don't we take a timeout?
Yes, sir.
You guys shuffle, figure out which card we're gonna play, which is the best one to get done. Let's get it done today, okay?
Okay.
All right, so I'm gonna give you some time. I apologize, Flo. Apologies, sir. We're gonna give you one more time. We're gonna figure out what's the best way to communicate. So if you let her know that, then we'll come back to it, okay? Thank you, Jessica. All right, commissioners, we're gonna go on to item J, motions for rehearing. Robert Reyes. Okay, Mr. Reyes.
Mr. Chairman, Commissioners, thank you very much for the time today. Robert Reyes, Assistant General Counsel. This motion for hearing is in regards to the matter of Adrian Becerra. Mr. Becerra's motion results from a default order in which the department revoked his Class A barber license based on his criminal history. Mr. Becerra argued in support of his motion that he did not receive any notices of the case against him as he had moved to a new address. I reviewed the file and found that the notice of alleged violation was sent to 2 addresses, one of which was Mr. Becerra's address of record, as that address is found in our licensing database. We also sent it to his to the same address, and that address that he provided was on his license renewal application. So just to summarize, we sent it to 2 addresses. Sent one address was on his current profile, licensing profile, and also that same address was on the renewal application. So we see it 3 different places, 2 of which he provided. The NOAV was marked delivered at that same address, and I made sure and confirmed that through the USPS tracking service. A review of the file found no evidence that Mr. Becerra had attempted to notify the department of any new address, which is his duty under the barber and cosmetologist program rules. The department perfected service by sending both the NOAV and the notice of default to respondent at his address of record, which he also voluntarily offered on his renewal application. Based on the information available to me, I recommend that you deny respondent's motion for rehearing. I'm available for any questions you may have.
Any questions, Commissioner? Yes, sir. I'll take a motion.
Don't move to deny.
A second?
Second.
Say aye.
Aye.
Opposed? Thank you, Mr. Reyes.
Thank you, sir.
Couple of things, Commissioners. Nope, Dr. Callis got called away, so he will be done. And so the second is, I'm gonna offer Ms. Lowe an opportunity to be virtual, so she doesn't have to drive back here. And I'll make that exception for her. And so we're gonna, that way she has her interpreter and her space, so we'll do it. Thank you. So, we're working through that, so stand by on that. Item, you guys keep throwing this at me, I'm telling you. K, we're gonna go to K. Mr. Leary. Good to see you, Mr. Leary.
Good to see you. Good morning, Commissioners. Stephen Leary, Assistant General Counsel. Item K consists of a rule package in the Used Automotive Parts Recyclers Program. The proposed rules implement Senate Bill 224 from the 88th regular legislative session, the Deputy Darren Almendares Act, which relates to the topic of catalytic converter theft prevention. That act required cooperation between our agency and other agencies to help address the topic of catalytic converter theft, and requires certain record keeping to enable our agency to identify red flags that catalytic converter theft may be occurring and provide that information to the Motor Vehicle Crime Prevention Authority and partner agencies. These rules were developed with input that we received from a summit that we held in August. And they clarify record keeping responsibilities relating to catalytic converter transactions. The proposed rules provide that licensees must maintain transaction records for catalytic converter sales for a period of 2 years and must make these records available to the department for inspection upon request. These rules also make other clarifying changes to the rules, including some changes that were suggested during our 4-year rule review process. The rules correct outdated statutory references in the rules, clarify the duty of licensees to maintain records, provide, and the requirement to provide the department with updated contact information. It also clarifies that used automotive part recyclers have to remove the registration sticker from the vehicle in addition to the license plate. As an issue we received some questions about over the years. The rules also make other non-substantive changes to the UAPR rules. The proposed rules were published on the Texas Register on December 20th. The comment period ended January 21st. We only received one comment, and it wasn't a relevant comment. It didn't express an opinion one way or another on the rules. The advisory board last met on March 6th and recommended adoption of the proposed rules without changes. I recommend that the commission vote to adopt the proposed rules with an effective date of May 15th. And I'm available to answer any questions.
Any questions, commissioners? I'll take a motion.
So moved.
There's a second.
Second.
All in favor, say aye. Opposed? Carried. Thank you, Mr. Leary. Mr. Red. Item L, commissioners.
Thank you, Mr. Chairman, Commissioners. Once again, Robert Reyes, Assistant General Counsel. I am presenting the athletic trainers rule package that amends Chapter 110, Sections 110.24, 110.30, and 110.70 of the Texas Administrative Code. The proposed rule amendment at 110.24E will improve the license renewal process by adding an affirmation statement that the licensee will acknowledge that they will provide all services as specifically directed by a qualified health professional, with the directives provided being kept current and in a written format available for review if requested. The proposed rule amendments at Section 110.30, paragraphs A and B, update the temporary licensing requirements to now require a passage of the written portion of the licensure exam, with the expiration of the temporary license coming on the last day of the month of the next scheduled practical examination. Finally, the proposed amendments to 110.70A update the standards of practice to include the physician delegated authority document. The document must be obtained before an athletic trainer practices, be kept on file with the athletic trainer's license, and available for review. The physician delegated authority document must have the contact information of the sponsoring physician and renewed each time the sponsoring physician changes. If adopted, the proposed amendments would improve health safety standards, as clear documentation of the services that may be provided by the licensee will clarify expectations and eliminate confusion. By adding the qualification of passage of the written exam to the current educational and apprenticeship requirements, the proposed rules will help ensure that individuals with temporary licenses have the requisite knowledge of athletic training principles to be in the field. The proposed rules were published in the Texas Register for comment on December 27th, 2024. The comment period closed January 27th, 2025. There was one comment received, but it did not directly opine on the substance of the language. Therefore, no changes were made to the language as it was published. The proposed rules are being presented for your review and vote. As they were published in the Texas Register, I recommend that you adopt the proposed rule amendments with an effective date of June 1, 2025. I'm available for any questions you may have.
Thank you, Mr. Ray. Any questions, commissioners? Take a motion.
So moved.
Second.
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you.
Thanks, sir.
Mr. Funderburg. Item N, commissioners.
Morning, Chairman, Commissioner. Christopher Funderburg, Assistant General Counsel. Item K consists of amendments to the rules governing hearing instrument fitters and dispensers. The changes affect continuing education requirements for hearing instrument fitters and dispensers apprentices, license holders, and CE providers. There are two main sources for these changes: the department's own internal 4-year review and HB 1560, the department's sunset legislation. The sunset legislation removed detailed requirements regarding the number of CE hours, the methods of CE delivery, the types of CE providers, and the approval of CE providers and courses. It also provided broad rulemaking authority under Texas Occupation Code 51.405 regarding CE requirements and CE providers. The proposed rules rely on these sunset changes to revise and or eliminate some of the CE provisions previously required by statute. Proposed rules allows more flexibility on the methods of CE delivery and the types of CE hours that may be obtained, and they eliminate the need for individual CE courses to be approved by the department. Now I'd like to provide a brief roadmap of the changes proposed by these amendments. The proposed rules add new definitions that will be imported later in the subsections of subchapters E and H that set CE requirements for HFD apprentices and licensees. There's been substantial amendments to subchapters E and H, but most are just for streamlining and simplification, and they don't really change any existing requirements. The proposed amendments also change CE provider requirements. In particular, would no longer obligate the department to approve each CE provider course, which is to our licensing division. Most of these changes to the CE provider requirements affect the department's duties and not HFD licensees generally. Finally, in subchapter F, there's been a restructuring of the CE provider registration fee, both the initial and renewal. The renewal period proposed to be changed from 1 to 2 years and from 200 to 400. The rule of account for providers who may renew prior to the implementation of these amendments. Rule package was filed with the Texas Register on November 15, 2024, and published for comment by the public on November 29th. The comment period closed on December 30th, 2024, and we received one comment. The comment was submitted by the organization Texas Hearing Aid Association, THAA's. Comment did not directly address the content of the rule package, and no changes are recommended in response to the comments received. Recommend approval of the proposed rules with an effective date of May 15th, 2025, and I'm available to answer any questions.
Thank you, Mr. Member. Any questions, Commissioners? I take a motion.
So moved.
Second.
Second motion.
All right. All in favor, say aye.
Aye.
Motion carried. All right. Item N. Wendy. Hello. We missing Wendy here? Charles?
I believe so. I'm sorry. We just.
I'll look it up.
She is present. She is present, Mr. Chairman.
Okay.
She's in the building.
Go to the penalty matrix, item O. Who's gonna be doing that?
Good morning, Commissioners. My name is John Medlock. I'm the Chief Prosecutor for the Department. I bring before you today updates to the hearing instrument fitters and dispensers penalty matrix. As a reminder, the penalty matrix serves as the guide for the prosecutors when seeking to assess administrative penalties and or sanctions. It does not create new law. It simply takes existing law and rules and centralizes it into one document and seeks to group violations into classifications in order of severity of those violations. This document, which will be published both in the Texas Register and our website, gives licensees and the public notice as to the amount of possible penalties and or sanctions, sanctions for any given violation. Also of note, while the penalty matrix is binding on prosecutors, it is not binding on the commission when you decide cases such as the ones before you today. There were only minor changes to the penalty matrix, most of which were updates to rule and statute citations. The only major addition was to include violations for CE provisions required of hearing instrument fitters and dispensers. These updates were presented at the March 4th, 2025 meeting, where it was unanimously approved to send to you for consideration and adoption. I would ask for you to move to adopt the update to the penalty matrix. I'm available for any questions.
Any questions, Commissioner? I'll take a motion.
So moved.
A second.
Second.
All in favor, say aye.
Aye.
Opposed? All right. Thank you.
Thank you.
Ms. Pello. Item N, back to item N, Commissioners.
Thank you. Thank you for returning to item N. Wendy Pello, Senior Assistant General Counsel. Before you on item N is the 4-year rule review. We've got 12 rule chapters that are currently undergoing review. Just a little background. We review these rules every 4 years, determine if they're still necessary and whether they should continue to be readopted. And we conduct the review, a legal review in GC, but we also conduct a division review with all of our divisions to get their input. We also publish a notice of intent to reviews for the public is aware that we're reviewing those rules and that they can provide input as well. For the current rules that we have, we published that consolidated proposed an attempt to review that included all 12 rule chapters. It was published November 22nd, 2024, and that public period closed December 23rd, 2024. And we received 53 public comments spread out over those 12 rule chapters. We reviewed all those comments. For any public comments regarding readoption or repeal of those rules, we took those under consideration as part of this review. Any comments that were requesting changes to the rules, we'll take those under consideration for a possible future rulemaking. We can't make those changes now since the public and the advisors, no one's seen what the specific changes may be. So we want everyone, if we do proceed with rulemaking, the people who have not that opportunity to review the rules and the specific changes and offer public comments. And no further rulemaking action will be taken on any comments that were suggesting changes to the statute or changes to rules that would first require statutory changes to be made, or any comments that were unrelated to the rule review. And so the department has reviewed each of those rule chapters, and we've determined that the rules are still necessary and they should continue to exist, and they're essential in implementing both the enabling statute, the program statutes, and any other statutes affecting state agencies. And again, based on our review and the public comments, there may be proposed rules in the future, but again, that would go through our standard rulemaking process with the rules being published in the Texas Register and open for public comment. And so today, for purposes of the rule review, the department is recommending the commission adopt those 12 rule chapters listed under agenda item N in their entirety in their current form as a result of the 4-year rule review. And we have a recommended effective date of May 1st, 2025.
Thank you, Wendy. Appreciate that. Catch your breath. It's gonna be okay. Any questions?
Yes, Chair.
Go ahead.
I think I did ask a question to General Counsel because there are several advisory votes on this one. I'm pretty sure he mentioned that they don't need to approve this or the rulemaking it rests here. Is that something I didn't understand his terminology right there?
The rule review is a process. It's required of all state agencies. We go through every 4 years, and it's making sure that agencies look at the rules. Are they still necessary for the reasons that we put them in place originally? Do they still exist? Our statutes will require rules to be adopted on a specific issue or allow the commission to adopt rules on a specific issue. But we're not proposing anything specifically. There's no strike throughs or underlines, no additions or anything to be deleted. It's just we're reviewing this and we're putting this out to the public. And then, advisory board members want to comment, public wants to comment, everyone, comment and support their ideas of whether the rules are still necessary, they're obsolete. And so we get to this point to close the rule review process. We're doing the evaluation, we're taking notes where there might be changes going forward, but that will be a separate process. At this point, we don't need the advisory boards for the rule review. And the next stage, like if we've received comments and there are advisory boards, for those particular advisory boards, depending what those comments are, they would maybe go to those advisory boards and say, these are the comments we received on the rules, and then develop rules.
Council, I'm confused. We have received comments right there. That's what you said, 53 comments we have received.
Yes.
So are those comments part of the rules, or those are still going to be evaluated and put into the hopper?
We've evaluated them right now into 4 broad categories. The first are those that said, hey, we agree, we think that your rules are still necessary. We support their, continue to be readoption. Or if anyone had said, we think they should be repealed, we don't like your rules, and just in that kind of blanket statement, that's one category. And so those we can consider as part of this rule review. In terms of, we considered your comment that said, yes, we should readopt the rules, we agree, and move forward. The second category is kind of the biggest category, and it's proposed changes to the rules. And people can have all sorts of ideas about what they want to see the rules be in the future. We can't incorporate and make those changes right now because no one else has seen those changes, seen what the proposed changes are. So that's a big category. And then we've got category 3 and 4. And category 3 is where folks have offered comments, but what they're making changes to are changes to the statute. And that's something the Texas legislature has to do. Or they've made recommendations to rules, but to be able to change those rules, you have to change the statute because the rules may be reflecting what the statute is.
Yeah, thank you for the clarification.
Yeah.
I just want one more follow-up on this one, chapter 115, which is a midwives right there. Given that folks are here complaining about our rules or whatever it is, it's, I think we have received, what is it, 6 from the interested parties right there. Is there a timeline or something that we can look into it to get those rules updated and whatever got to be incorporated? And maybe we got to have a chair, if you don't mind, have that as a midwives as a separate category right there for people to comment and all, because it's becoming quite sensitive lately.
It's not lately, it's been over, but yes, we'll be adding midwives to the agenda for the next commission. Yes.
Thank you. Thank you. I don't have questions.
Hopefully that clarified. So the comments are not lost. It's just that we're limited to what we can do right now at this stage of the process. And that's like, we'll take those comments we're proposing, or people had offered suggested changes, and take those to our advice board and have more in-depth discussions about whether we want to make those changes or not.
Absolutely. Thank you. Any other comments, questions? I'll take a motion.
So moved.
Second.
Second motion.
All in favor, say aye.
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 Vote. Motion carried. Thank you, Ms. Pello. Thank you, Brett.
Thank you, Wendy. Good seeing you.
All right. Commissioners, with your approval, permission, I'm going to Ms. Jessica, we're gonna defer them to the next commission meeting. They've been informed on how to get their interpreter on there, because we can't interpret due to bias nature. So we're gonna defer them and allow them to be virtually to appear as opposed to driving back remote. Okay? All right, we're gonna go to item P. Investigation of veterinary. Pam Pigloni, is that right?
Dr. Pam Pigloni,
Yes,
she is not present.
Oh, she's not, okay. She's not present. Oh, yeah, she did.
Right. My name is Kelly Phelps. I'm general counsel for the Board of Veterinary Medical Examiners. Thank you for having me here today. It's my understanding that no oral argument was requested on this, so I'm just going to give you a very brief procedural history of the case as well as the board's recommendation. At its meeting on February 20th, 2025, the Board of Veterinary Medical Examiners considered the application for licensure of Dr. Catherine Leone. The case was filed at SOA on May 22nd, 2024, and set for hearing on July 10th, 2024. On June 10th, 2024, the board kindly filed a motion for summary disposition, asserting that as a matter of law, Dr. Pam Pigloni is not eligible for a special license to practice veterinary medicine in Texas, nor would she be eligible for a standard license. Dr. Pam Pigloni did not file a response in opposition to the motion. On July 2nd, 2024, the administrative law judge, Robert Pemberton, issued an order granting the board's motion for summary disposition in full, closing the record and canceling the hearing. On July 10th, 2024, the administrative law judge issued a proposal for decision containing findings of facts and conclusion of law, and recommending that the board issue a final order that respondent is not eligible for a special license or standard license to practice veterinary medicine in Texas. The proposal for decision was properly served on all parties who were given an opportunity to file exceptions and replies. Neither the board nor the respondent filed exceptions. And on July 26, 2024, the administrative law judge issued a no exceptions letter recommending no changes to the proposal for decision. The board convened on February 20th, 2025 in an open meeting to consider the proposal for decision in this matter. The board present voted unanimously to adopt the proposal for decision as written. We have recommended one technical change to the proposal for decision. Finding of fact number 8 erroneously lists the motion as being filed in 2023, not 2024. We request that you adopt the proposal for decision with this change.
Any questions? I'll take a motion.
So move to adopt the PFD as recommended with the technical change.
Second.
Second motion.
All in favor, say aye.
Aye.
Opposed? Motion carries. All right, Ms. Phelps, you're item Q.
Yes, I am also in here.
Oh, you and Mr. Reyes, both? Okay.
So again, Kelly Phelps, General Counsel for the Texas Board of Veterinary Medical Examiners. I'm here presenting the vet board rule package that amends chapter 571, section 571.7 F1 of the Texas Administrative Code. The proposed rule amendment extends the time period in which an applicant for veterinary license who has not yet graduated from veterinary medical school must obtain a document confirming their expected graduation date in order to apply for the state board examination from 60 to 120 days. The proposed amendment was suggested by a major stakeholder, Texas Tech University School of Veterinary Medicine, to align with its schedule for students in their final year of vet school. Texas Tech's fourth-year students spend most of their year at externships throughout the state, but return to campus in February of the year they graduate. Texas Tech, in an attempt to limit costs to their students, wants to proctor a state board examination for their graduating students in February, while the students are all on campus. By allowing the students to obtain a document confirming their expected graduation date 120 days prior to graduation, this allows the Texas Tech students to take the state board examination on campus in February prior to the graduation. This change will also benefit all graduating veterinary students, both in-state and out of state, in that it allows them to take the state board exam sooner after confirming their qualification. Allowing the students to take the state board exam sooner gives them one less thing to worry about in a very stressful time right before graduation. The proposed rule amendment was published in the Texas Register on November 1st, 2024, and the comment period closed on December 16th, 2024. No comments received during the comment period and no changes were made to the proposed rule amendment. The proposed rule amendment is being presented to you for your review and vote, and it was published in the Texas Register. I recommend that you adopt the proposed rule amendment with an effective date of May 15th, 2025. I, as well as Robert Reyes, are available to answer any questions. But very briefly, before I do, I just want to express my gratitude to Robert, who has been helping us through this rulemaking process. I know the vet board attachment has been at times difficult to navigate, but we very, very much appreciate his expertise and guidance and helping us through this rulemaking process.
Excellent. Any comments?
Yes, sir, please. Robert Reyes, Assistant General Counsel. It's an honor to work with Ms. Phelps in this rulemaking and guide her through this TDLR rulemaking process. As you know, it's very daunting, very long, very painstaking to make sure that we're transparent, that we make sure that all parties that will be involved or affected have their right to offer input on the rules. And so this was the first rulemaking where the Board of Veterinary Medical Examiners and TDLR have worked hand in hand through the entire process. So just want to offer my thanks to a few individuals who made this happen as well. I would like to thank Monica Nunez and Shamika Mason, who are our rules coordinators in the Office of General Counsel. They facilitate all the communications with the Secretary of State for rule filings that we produce. So everything that we want to put out to the public for their input has to be followed the Secretary of State through the Texas Register. They help facilitate all that. They also keep all the attorneys who are drafting rules on timelines, so they keep us on schedule. They keep all the trains running on time. So I definitely want to thank them for their expertise and their communications and their timeliness. I also want to thank Elizabeth Salinas Strickmatter, Dalma Sotero, and Stephen Leary. They're Assistant General Counsels here in the Office of General Counsel for TDLR. They've been reviewing the entire administrative rule set of the vet board with Ms. Phelps and Ms. Sharkey, helping them develop ideas and concepts that will allow them in the future to be more clear, efficient, and effective after amendment. So this review has a massive crossover with rule drafting, and they have spent many hours with Ms. Phelps in this endeavor. So I appreciate what they've done because they've spent a lot of time with her and looking through these things, through this rule set. My thanks also to Executive Director Ms. Sharkey for her energy and support in this project. Despite her schedule and responsibilities, she's been a part of many meetings and email chains regarding this initial rulemaking in regards to that came from this attachment process. So I greatly appreciate her time. And lastly, my thanks to Ms. Phelps, General Counsel, for her willingness to learn in this situation. As I just said, it's a very daunting process, and we have about 39 steps in our rulemaking process. And with what she is going through, not only for just the rulemaking, but every other job that she has to do. The time that she's taken and the commitment that she's making that she's made to get through this rule process and to learn will help TVVME in the future. And I'm just so happy to be a part of it and offer, my help in the way that I did. So thank you all very much for your time.
And it is a duck. There are a lot of busy feet underneath that water, and it is a daunting.
Feverishly working.
I would like to add an amendment to favor A&M over tech if that's possible. We'll talk about that later.
That's exactly right.
Blowback would be severe. All right, Commissioner, any questions?
Yes, Mr. Chair. Oh, if I may. Thank you, Commissioner Sadoo. Ms. Phelps and Robert, I really appreciate you thanking your coworkers. That mindset and spirit of gratitude, I think, opens many doors and keeps people communicating and collaborating together. Robert, you mentioned everybody but yourself. And I appreciate that because they need to know that they're appreciated, just like you need to know you are, and you are. You've done a tremendous job, and I thank you for your tutelage. But Ms. Phelps, they're going to go off and do wonderful things, and they'll always have people like you and the TDLR to thank for that. So thank you to your staff. Thank you for being so open, Ms. Phelps, and I think you've got a lot to learn at the TDLR. I think we're a wonderful agency, and I'm probably telling you things you already know, but thank you both.
Thank you, sir.
Any other comments?
Yes. You said how many steps you gotta go through?
39 steps.
39.
Is there a new word going around through the country? Call it Doge. Can you do that one?
I
Don't answer that question.
Touch Ms. Pello after me.
All right.
Name's General Counsel Commissioner Drockstrom. It's actually to keep us more efficient and accountable, believe it or not. So
That's right.
we kind of have the model rulemaking process. And we're happy to walk you through it sometime. So
No, I'm a one-step process right there.
All right, any other questions? All right, I'll take a motion.
So move with the date as proposed.
All right. Second,
Second.
all in favor, say aye.
Aye.
Opposed? Motion carries. Thank you. Thank you
Thank
so
you all.
much.
Appreciate it.
I need a motion for continuance on Ms. Lowe's case for next, if you don't mind.
So moved.
There's a second.
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 All in favor, say aye.
Aye.
Opposed? Okay. Doug? Are you good with that?
yes, sir.
All
And
right,
we will
good.
provide. I informed Ms. Willow that we'll reach out to her and that she will have the opportunity to appear virtually. So to save them a drive because of today's confusion.
Happy to do it. Happy to do it. Thank you. And again, the burden was make sure she's clear when we set this up, that the technology is available, that it can flow for, it's gonna be an extensive conversation.
Yes.
Okay. Going to item R.
Yeah, can you go and ask, maybe some question, Jeff Butler will be.
Okay, that's fine. I can do that, sure. We'll go to item S. Let's go to advisory board. We'll do that.
That's you.
Who's gonna handle advisory board? Okay, Brandy?
Great. So you have a memo in front of you that has all of the appointments. There are quite a few for this go round, so I will ask for patience and I will also ask for forgiveness should I mispronounce any names. All right, starting with appointments. Advisory Board for Athletic Trainers, Joseph Everhart. For the Behavior Analyst Advisory Board, Jessica Shirley. For the Combative Sports Advisory Board, Anish Padi. Motorcycle Safety Advisory Board, Douglas White. Air Conditioning and Refrigeration Contractors Advisory Board, Jerry Bittner and Dolores Compion. Barbering and Cosmetology Advisory Board, Ledettrick Leonard, Mary Pascal Lindsay, and Salvador Flores. For the Licensed Breeder Advisory Committee, Cynthia Rothermel, Dr. Valerie Devaney, Vanessa Kirby Gagne, and Amber Green. For the Board of Boiler Rules, Palmer Dent III. For Code Enforcement Officers Advisory Committee, Jose Victor Baldovinos and Kenneth Rocha. For the Combative Sports Advisory Board, we have Dr. Luis Chapa. For the Driver Training and Traffic Safety Advisory Committee, Carlos Reyna and David Bruce. For the Electrical Safety and Licensing Advisory Board, Mark Matheny and Troy Webb. For Elevator Advisory Board, Sheila Sweat. For Mold Assessment and Remediation Advisory Board, Marion K. Armstrong. For Motor Fuel Metering and Quality Advisory Board, Adam Thompson, Nathan Wickelman, and Terry Haram. Orthotis, this is the one, it's not a name, it's the board. Orthotis and Prosthesis Advisory Board, Mark Kirchner and David Arentz. Registered Sanitarian Advisory Committee, Aaron Dunn and Terry Barber. Towing and Storage Advisory Board, Tasha Mora, Charles Rash, and Ken Olmer. Water Well Drillers and Pump Installers Advisory Council, Alvaro Rosales and Don Piper. Weather Modification Advisory Board, John Bear Aber. And for presiding officer appointments, for the Licensed Breeder Advisory Council, we have Cynthia Rothermel. For the Motorcycle Safety Advisory Board, Jerry Alford. For presiding officer reappointments, for the Massage Therapy Advisory Board, we have Carolyn Grin. And for the Mold Assessment Remediation Advisory Board, Chris Jeter. Towing and Storage Advisory Board, Tasha Mora. And lastly, but not least, Speech Language Pathologist and Audiologist Advisory Board, Jerry Sanford Graham.
Thank you, Brady. You did a great job. Commissioners, any questions?
Sure, I want to thank you. I think, if you look at this one, it represents more like Texas right there, because we had quite a disagreements in the past right there, but this is probably, you put on that every part of the state. I do see this one. Thank you.
Thank you for your nominations, too. Yeah, good job. All right. Your motion? Second?
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you, Brandy, again. Do you need to say something, Courtney? Okay. All right. We're going to item R, examinations. And I think, Commissioners, you have we're going to do the 5-minute version.
Okay.
Okay? Sure. But we want to go through this examinations. I think your presentation's in front of you. So go ahead, Courtney.
I actually, Todd Forrester and Lorraine Stroop provided that, and it provides a lot of detail about the current process for exams. If it's okay with you, since we're doing an abbreviated version, I'm going to talk a little more about how we are using our current structure to expedite something for one of our community colleges to ask for our help. So if you'd like, we can go through those slides, but that's a little more of the as is and the how it works currently. I'll just start by saying, we are the Department of Licensing and Regulation. Regulation, we're very focused on health and safety and making sure that the people that benefit from services of our licensees, that it's done safely. On the licensing side, TDLR has a long history of, you ever remind the group, 962,000 licenses or renewals at any given time, has a long history of making the licensing process as fast and efficient as possible. At the lowest cost available to our licensees. So in that same vein, we're still very focused on that. But part of the licensing process for many of our licensees is an examination. And I've heard since I started in June of last year from multiple licensees that, particularly in the month of May, that there is a swell of activity that needs to happen as students prepare to graduate, or high school students or community college students try to wrap up their coursework, apply for an examination, and then apply for a license. And so we realize on the licensing front, we're trying to do it as low cost as we can and as quickly as we can, because people need to get to work. Their livelihood hangs on that examination, the successful completion, us being able to provide it quickly, and also for us to be able to hand off that license very quickly. We've worked really hard on the licensing front to do that, and you see that in your monthly numbers. We partner primarily with PSI, who I will say is a wonderful partner, and they do more than 110,000 licenses for us every year. And even though the month of May, we have this swell and our schools experience some delay, I think overwhelmingly people have been very complimentary of PSI. But I want to tell you why we're looking at a different approach and doing a pilot with the school who asked us to do that. We have the authority as the agency to develop our own exam, to approve someone else's exam. Most of our licensees either take a national exam or an exam through PSI. And again, PSI does a great job and we found them to be a very good partner. But San Jacinto College approached us a few months ago at the very end of 2024 and mentioned some of these struggles, that they have students who really want to launch into the workforce. You know that community colleges are held accountable to that next step. the student needs to go to the military or to work or into some other education. And so they're very focused from all different angles on making sure that the students launch. They approached us asking if they could potentially conduct their own exams. Well, we have a responsibility to make sure that whatever exams are provided in the state of Texas is either done by a third party or we've had some testing expert. I can't remember the language in the law, but there's specific language, specifically like in cosmetology, that it has to be from someone with very specific skills so that we don't just say, sure, go ahead and do that, because we know that the market is going to prove out whether the person gets and keeps a job, and we want to make sure the exam they take fully prepares them for that. So we've been partnering with San Jacinto College. We're working on an agreement with them to formalize the agreement on paper now, both between them and the testing company and us, which will allow them to serve as a testing center in the month of May for their students in massage and cosmetology who are ready to launch. We, as a licensing agency, are also, in fact, I almost want to stop and say, if you've touched this program in some way, raise your hand. There are a bunch of people in the room that are working on this pilot. So when I say that it's a group effort with the intent of helping this group of pilot students move into the workforce quickly, yeah, you can raise your hand. All of you can raise your hands too. So what we're doing, we've worked through a process with them that they are going to, for the written exams for cosmetology and massage, they will be serving as a testing site for their students. So they'll work with PSI. We've confirmed that, of course, it's a community college, so they have a good testing lab and they have good processes, which makes this very easier. Sorry, the staff are like, nothing easy, Courtney. Easier because they have a good structure already and they have a system set up. So they're serving as a PSI testing site so that when the students have completed the sufficient amount of coursework, they can take the exam. Our responsibility, in addition to orchestrating this pilot with the college and with PSI, we are also going to expedite the license for these students so that when these students walk across the stage in May, they will have their exam scores and their license and leave that ceremony where they might currently have to leave that ceremony, schedule something else, and then work with us on the license.
Yes,
So we're talking about a good number of students. I do want to say we're taking a very thoughtful approach because PSI administers more than 110,000. In order for us to allow schools to do this, we want to both work with PSI to ramp up their capacity so that schools can make sure their students have opportunity to test very quickly and not just scattershot. Yes, sure, send us your exam, and that we start trying to approve multiple exams for multiple different organizations. So we're doing a lessons learned session along the way. We're going to do this with San Jacinto College for at least 3 semesters to see what lessons we would learn, how we could do this differently with the goal of letting them do that. I will tell you one piece of this, maybe the most controversial of all, is that their cosmetology practical is something that we are allowing them to use their own practice test as the practical. The reason being, for the last 5 semesters, San Jacinto students have passed the PSI practical test at 95.6%. So the practice test they have developed for purposes of this pilot is being approved for the final. And so these students will go through that process with San Jacinto administering their own, the PSI written exams for those students, and then their own practical exam for cosmetology. And so on May 16th, I believe, is the graduation. All of the students in those courses will have everything in hand to then, and they can start applying before graduation because they will have everything they need to show an employer they're eligible for work.
Outstanding job, Courtney. Outstanding job telling me to be a part of that.
Lots has gone into this, and if it sounds at all easy, it isn't. You saw the number of hands, but we want, for the benefit of the students in Texas, to do everything we can while also recognizing there's an administrative burden. So we have to be thoughtful about how we do it and working with PSI to make adjustments to their model so that the month of May is smooth.
Okay. Is there a motion required on this?
There is not, it was informative.
Yeah, actually, I look at the agenda as this discussion of possible action, so I think action to imply action by the commission. But that's my interpretation.
What kind of action are you looking for?
It's just
This was intended to be informational. Should you like to take a vote to allow us to continue the pilot with San Jacinto in the way I've just described? I think it would be appropriate for you to vote on that.
yes.
But Chair, I want to ask on the discussion.
Go ahead.
I want to commend what y'all are doing. If you know this one, the junior colleges and the technical colleges are state operated or get some funding from public right there. Fair enough. The question is, the commission has a latitude to take their exam as the exam on record for licensure. The reason I'm asking is what caught my attention was these students are taking loans to go to the schools, and then they do take a test right there, which is basically administered based on, there's a time lag right there. And it takes about, 3 to 6 months. Whereas if I graduate from whatever the school it is, I can go and work, but they're having problems right there. So this pilot demonstrates that it can work right there. The other stuff is, we have a vendor, I don't want to say the numbers, but the fee, what it is being collected from the students, in my perspective, is pretty high. And I don't know, I think, we got to look into a different model right there, where, that's what the model right there, they can charge what it is. But why not we allow the educational institutions, and you as an executive director can take their final exam, and if the administrator or whoever recommends that these are the people you can license right there because they are part of the either technical school, state technical school, or a junior college funded by the local tax dollars right there. That's something I think, probably we got to take it to the next level to evaluate and see what can be done right there.
I hear the concern and I appreciate what you're saying. I'm looking at the cosmetology language right now. It's written exam must be validated by an independent testing professional. So while we do have the authority to approve exams developed outside the model we're using currently, and as I mentioned, some use a national exam, but the exam process is not a simple one. The methodology behind the exams, the metrics behind exams generally rise to a level that that it's harder to do than just develop a paper exam. It needs to be validated by an independent individual. However, we are open to that. And if a community college brings a solution to us, I know there's been discussion and PSI is aware of this, that some community colleges have considered whether they might contract with someone differently, including PSI or another testing provider. We would be able to approve that so long as it's done in accordance with the statute.
It's a great first step.
If I may, yes, Mr. Chair. This is an incredible example of this agency not just trying to reform within, but reform without. We didn't have a mandate or anything. There's a goal in mind of serving Texans, serving the most humble of them, people that are looking for vocational licenses just to get out in the workforce. It was very compelling. Was it your mom that was a cosmetologist?
Yes.
Her mom was a cosmetologist that was trained at San Jacinto College. And she went out and built a career, and we're benefiting from that now. And so all we're trying to do is lessen the burden, lessen the friction, lessen the cost of these people getting out in the workforce. And that's exactly what we're called to do. That's exactly what our purpose is here. Make it as easy as possible to get those licenses, to make sure the standards are met. But one state agency is working with another state agency, just out of sheer will to make it easier for Texans to get to work. I can't even begin to tell you the waves that this has created. We have other community colleges have reached out from across the state saying, what can I do to participate in this program? Because they want to get their students to work right off the bat. And so this is something that when we look back in a few years, this makes so much common sense that we're all it took me 12 years to think of, wow, what a great idea. And that's kind of embarrassing, right? But we're going to look back and go, of course that's the way it should be. Of course that's the way it should be. And TDLR is going to be the agency that is prized for doing things like that. So because of that, we're probably going to get more programs the way we always do, and we're always going to run them well the way we always do. It's in our DNA. So thank you. Thank the staff for being open to considering the idea. I know community colleges are on fire, and they're waiting in line to be next. And so thank you all. I can't tell you how overwhelmed I And I know the students, we visited with the students last week. Steve, was it? It's gonna be incredible. This is earth shattering.
All right, I'll take a motion.
Chair, can we table this because I want further discussion down the line, so maybe next time they can come back.
The motion is just for them to continue. That's
Yeah.
it.
Oh, okay.
Okay, that's all. Sure, you want to make
Yes,
that
I'd
motion?
like to make the motion. We, continue the pilot program.
Second.
All in favor, say aye. Opposed? Motion carries. Thank you, guys. Thank you so
Hey,
much.
Mr. Chairman,
Yes, sir.
hey, I just have a quick comment on examinations. And this is from something that happened probably a year and a half ago, but it just brought it back to my memory. Since I'm slow, it took a year and a half, but I talked with people. PSI, make sure if we have a third-party administrator, what happened on a test a year and a half ago, PSI had nobody show up. They had one person that was going to man the office for that day. They didn't show up, and there were 26 people that were coming to take a cosmetology exam. And they just went to the door. They didn't get any kind of notice and were told, hey, it's not open today, or there was a sign on the door. And it was going to take them another 3 or 4 months to get rescheduled. And I just want to make sure when we're looking at a third-party supplier for exams, that they have backups or they have more than one person. So if somebody's sick or somebody doesn't show up, we don't have all of these examination people come in and they're told they can't do it today because that just puts them off for another time. So I hope that's something that's used in evaluations for a third-party administrator on exams.
Thank you, Dr. West. That's great comments. We'll make sure to factor that in as well. Okay. All right. We're on the last item. D. Courtney.
Yes, thank you. We have a few agency reports to share. I'm going to go ahead and give a quick update and then hand off to Brandy, who has a legislative update, and then I'll come back to recent accomplishments. So let's start with the reports and statistics, and start with the legislative appropriations. Sorry, I went a long way to say Brandy's going to start with the legislative appropriations budget update.
We did take a long way to get there. But
I did. I really did. I was reading and talking and it didn't go well.
All right, Brandy.
All right. In front of you, you have a piece of paper that looks like this with like teeny tiny micro writing. This is our update in order to get it on one page. I do recognize that it's small. I commit to you that I will send this to you via email so that you can see it and digest it at your leisure. But the bottom line, what we want to do is kind of give you an update on where our budget is in the process of legislation right now. And so when we submitted our LAR, we submitted it with 9 exceptional items and a couple of riders. So to go to the exceptional items, exceptional item 1 was relating to our workforce, recruiting and retaining workforce. On the House side, they've adopted it at 50% of what we've asked for, and on the Senate side, they've adopted it in full. On the cybersecurity, the House has put that into Article 11, and the Senate has adopted that in full. For FCIC, the Senate has adopted it in full, and the House has put a portion of it into Article 11. For the emergency stop orders, that was one of our exceptional items. What was really fantastic about this is that the need relating to human trafficking is very well known, and both chambers adopted that into the base bill or into the introduced bill. So that exceptional item was already put into our base, and so there was no further determination of a decision that would need to be made for that, and it was given to us from go. That's the first time that this agency has seen anything come to us in the introduced bill, so that's a very big win. We're really excited to be able to have those funds to continue that purpose. Our help desk system replacement, the House has that in Article 9, and the Senate has it fully adopted. The PC replacement, the House has it in Article 9, the Senate has it fully adopted. The expansion of our fleet, that was put into House Bill 500 or the supplemental bill. It's been adopted by both chambers. in that. And then the artificial intelligence item is not adopted by either chamber. And then one of the biggest things was to also get the unexpended balance authority for the LSRP project. So as y'all did today, you voted on that, and we won't obviously have that completed by August 31st of this year. And because we are crossing the biennium, we have the need to make those funds go into the next biennium. Both chambers have adopted that, so that's fantastic. We have the funding that we need to continue that project. The combative sports tax rider that we asked for, the House has adopted it at 50%. The Senate has not adopted it at all. And then through our hearings, when we were in the Senate, we were talking about human trafficking, and Chair Huffman asked us if we were asking for enough. And so that gave us the opportunity to come back, revisit what it looks like for us to double or triple our capacity and how we're operating with our anti-trafficking efforts. And we ended up adding in 3 FTEs and the associated costs for that, which the Senate has also adopted through their decision process. So the bottom line is there's nothing really that matches between both chambers right now, with the exception of the authority. The next step is that it will go to conference committee. And in the conference committee, they'll hash out the differences, and we'll have final decisions of what that will look like. Once we get that, we're going to bring that back to you, commissioners, and we're going to have you vote on that as our operating budget for the next biennium. So that's where we're at, and that's what we continue to track. And again, I will get this to you in an email. Are there any questions that I can answer about our budget at this point?
Good job. Any questions? Okay.
Thank you, Brady.
Courtney.
I'll give a couple updates and I'll come back to you for the legislative update. Okay. How was that a little more succinct? All right. I want to just make a couple of quick notes on the note of recent accomplishments. We always list that on the agenda, and I don't always stop to take the opportunity. I know the deputies do, but I want to just highlight a few things that just to remind all of us on the level of work that the agency is accomplishing right now in the middle of legislative session, which you're going to hear from Randy about volume and what some of those the bill activity looks like. But I'll just say in my time in the Capitol this session, as you mentioned, Commissioner Butler, we've heard so many positive compliments and comments about TDLR. We know we don't do everything right all the time, but we do have a lot of confidence from legislators and a lot of trust that when we're tasked with something that we'll do a good job and we'll take input seriously and we'll make changes to make programs better for Texans. So I'm continuing to hear that when I'm in conversations, when Jeff and Alex, our governmental relations team, I know they're hearing the same thing and they're bringing that back. So I just wanted to take a note to thank everybody again in the legislative process, which is just about everybody in this entire agency who's doing something to build trust and maintain that level of trust. We are working on a return to office plan. You're aware that state agencies are returning to office where we've had quite a lot of telework, I'd say privilege and opportunity in the last few years. We are, with some exceptions in place, returning to the office full time. The North Campus returned to office full time on the 31st, and the EOT campus is returning on Monday, the 14th. We've had a lot of things to work out in doing that. Obviously, we had to make sure that everybody has a space, that we reacquaint each other with where we're sitting if you've been primarily remote for a while. But one of you also made a comment about a spirit of gratitude, and we've been talking as a leadership team about that also. Even though it's a different time, people are battling traffic. There are opportunities this summer to make sure that everything at home is taken care of, because we'll be in the office full time. Traffic is probably the biggest one. There's a lot of life happening for everybody, but traffic is one of the bigger ones. But in the spirit of gratitude, we have jobs. We generally like each other. We like working together. And so I also wanted to say a quick thank you to the employee resource group. We have a lot of people who volunteer to do extra things to make things special at TDLR, events and acknowledgements, and they've done a great job of planning an ice cream social at the North Campus, and we'll have one on Monday, and try to make it as celebratory as we can, that we're all going to be together again. So that is happening, and we're going to bring everybody downtown to the office starting on Monday. I want to also say thank you again to Dr. Gola and Brittany Sharkey at the Veterinary Board. We have, and for everybody that works alongside that team. Robert, you mentioned your relationship with Kelly and the staff. Doug, of course, spends a lot of hours. And a lot of people at TDLR do, but that has really gained more confidence from the legislature because we didn't go in warring with each other. We took the task seriously. We're about halfway through that attachment, and people see that not only is the vet board, subordinating to some degree to all of our processes and recommendations, but we're also doing it in a way that's collaborative. So I wanted to say thank you and highlight that. And then I always want to comment on our work on human trafficking. We have a team that is continuing to work. We've had 32 emergency orders to date and 51 establishment closures. And we're still looking for ways to do more faster with the least amount of administrative burden to make sure that when we find harm to members of the public who are both being trafficked and served by people that are being trafficked and may go into a massage establishment without realizing what is about to happen, that we're doing everything we can. So a lot of good work in addition to the day-to-day activity of licensing and enforcement. So thank all of you for everything you're doing.
All right, Greg.
I'm going to go to our legislative update next, and then you can just head into your update.
Okay, will do. All right, so I have the honor to give you the update of our government relations folks. They would have been here today, as you see on the agenda. It says Jeff Copus and Alex, so I'm going to try to level up to them as I get this report. They are at the Capitol. They are doing their whole legislative thing, so that's why they couldn't be with us. But they have provided this information that I get to share with you today. TDLR is tracking 545 bills that are impacting this agency. It is a new record. Congratulations, TDLR. There are currently 8,645 bills that are in the legislature. So again, records have been set this legislative session. Bill filing closed on March 14th. So at least the floodgates have closed, and now we get to handle what we have thrown at us. 28 TDLR cleanup bills and 7 strategic initiatives were filed this session. 9 of those cleanup bills were included in the Governor's Small Business Freedom Council report that was published on the 3rd. And I want to jump back real quick. Of those 545 bills that TDLR is tracking, 377 of them have fiscal notes attached to them that are having to be turned in. So we have Tony Pouillon working just tirelessly. To
About
make
10
sure.
a night, I think.
He looks tired.
But he does an amazing job, and through his work, we've also gained the trust of the legislature, as y'all have mentioned, because we're honest about our approach of what we really need to do this. I always say twice right the first time for the Texans. So the 7 strategic initiatives were in our strategic plan, and we're moving along with those. I'm going to skip a little bit because I know we're on abbreviated time. The initiative to create the Anti-Trafficking Intelligence Center was filed, and it has been referred to the Senate Criminal Justice Committee as of February 3rd, and we're waiting to hear the hearing date. Thank you, Commissioner Butler, for all of your efforts on that. Since January, the GR team has prepped leadership and staff for 34 House and Senate hearings. And I can tell you that that number is already out of date just because this was given 2 days ago, and they've already done more. This has included the Senate Finance, House Doge, House Appropriations, Senate Water, Ag, and Rural Affairs, Senate Business and Commerce, and House Licensing and Administrative Procedures. And we're communicating daily with our staff, legislative staff, and have scheduled and accommodated dozens of meetings with our stakeholders and these folks to get things across the line as they need to be. To date, the GR and TDLR division staff and attorneys have completed 57 bill analysis for bills with direct impact. I can tell you that number is already out of date. We've done more even since then. And then additionally, the GR team has handled more than 100 constituent cases for legislators, their staff, and the Office of the Governor has been delivering rule packages, 9 of them to the office of the governor, and notified 26 offices, legislative offices, of hiring events with TDLR with staff in their districts. So this team not only is handling the legislative lift that they have right now, but they're still continuing to do, I'll say, their normal daily work. So they've been doing incredible, and we just appreciate all of their hard work. So that's legislatively what we have ticking at the moment. Are there any questions about that?
Good luck. Good job. You good?
For the rest of my report, I will keep this brief. Like I said, for OSC, you've heard what's going on the GR side of that, but the website is getting over like 750,000 views per week. So there's a lot of stuff going on there. Hila and her team have been doing an amazing job of keeping things up to date and getting out to our stakeholders. We have 2 new web administrators that joined us on that team in January, and we have a new public information officer that will be starting with us on that team next week. So we're really excited about our expanded capacity that we're going to have to be able to serve. For that group, just so you know, 6.2 million communications have been sent out from January to February of this year. So there's a lot happening. For our financial services team, I want to brag on the mail team and our revenue team for just a moment. There is no workload challenge. They are consistently handling the mail that is coming in every single day. So when we're seeing reports that have nothing on them because they have processed everything through the division to get it moving on to our other divisions within the agency so that we can serve Texans faster and more efficiently. So congrats to that team and that leadership for making that happen. And this is over 83 pieces, 83,000 pieces of mail that they have been able to do this with just in this fiscal year. 50,000 of those were checks that had to be received in as well. So they're doing a fantastic job. For our facilities and asset and risk management team, they are assisting with a lot of the return to office requests as we're preparing for our staff to come in. There's modifications and things that are needing to be done. And they have just dropped everything to make sure that our staff are ready to come in. So I want to commend their efforts that they have put forward to make sure that we can have a successful launch of return to office. All of the fleet that we had last biennium that we had gotten the funding for has come in. All of those vehicles have been distributed appropriately to the staff that were needing to replace their vehicles across the state. And they've gotten that taken care of. And then all of the old vehicles have been surplus according to the policies. So they've been doing all of that as well. So that's just kind of the overview of what's going on. I can't talk too much about IT or ISO because stuff they do is kind of confidential, but I would say they're doing an incredible job. And I'm really honored to work with all of the teams that I get to work with. They do fantastic job for everybody every day. Steve Bruno.
Thank you. Steve Bruno, Deputy Executive Director for Licensing Services.
Can I ask a question?
Sure. Ms. Ready?
Yeah, Ms. Brandon.
Go ahead.
Ms. Myers' question is, I think, I had a complaint from someone about the complex website right there, trying to find out where they got a license or something. They got to be going through several variations or something. So did y'all take a look at it to see if everything gets redirected, or maybe if anyone has questions on license, just put this address or something to make life easier, because there's a complaint from a county official that on the program, something they're supposed to do, she couldn't get that one.
Okay, we'll definitely look
So
into
just
it.
take a look at that, something, if it can simplify their process, one email, something.
Absolutely. And if I could speak with you offline afterwards, I'd like to get the
I'm
details.
pretty sure something has been going on. I think, yes, yeah.
Yes, we'll get it handled. Thank you for letting us know.
Bruno?
Yes, sir. Thank you, Mr. Chairman and Commissioners. Steve Bruno, Deputy Executive Director for Licensing Services, with some quick highlights of the divisions that I have the privilege of working with every day. I'll go in alphabetical order. 52 members of customer service have answered just about on average for March, 36,853 contacts answered. That was 33,531 calls and 3,322 emails. Some of the efforts going on additionally in the past few months in customer service, we've got 2 new folks at the front desk. We get many people coming in for direct service every day to the EOT office, and they're handled by the customer service staff who often work in conjunction with licensing or education examination to meet customer needs. We've recently had some customer service representatives promoted. The quality score that the team uses to apply to itself, study and analyze on their works remains high at 92%. They're also working with our compliance division, specifically on skimmer complaints. There's been some cooperation between compliance and customer service to help resolve those skimmer complaints. And as always, with all three of the divisions that I am privileged to work with, and with all the divisions at TDLR, we're in a constant mode of staff development and ongoing training. So thank you. Thank you to everyone in customer service. Education and examination, 18 staff members in E&E, as we call it. Last couple months ago in February, for example, 8,979 exams administered. When you compare that to February of last year, it's almost 1,000 exams more. As again, I'll talk about, we continue to see growth. 598 curriculums approved, 1,990 emails specifically to E&E answered, 449 jurisprudence exams, and other efforts that continue are live sessions, trainings with our schools on our systems, continuing to implement going paperless. This was a completely staff-driven idea that paper was not needed in certain areas, and we were moving to electronic. There are other staff-driven ideas that continue that process of improvement. A couple of examples. One, not asking questions and not having applications ask questions that we don't need the answer to, because that spends extra time, and just continuing to find every possible way to provide excellent customer services. Every person in education and examination, I call them school and education specialists. Everyone has their roles and their titles. And it's just a great privilege and an honor to listen to them interacting with the schools and our licensees with the knowledge that every school is out there training our future licensee. And the more that we can provide to help those schools, the better that our licensees and future licensees are going to be. Just very quickly, two more sets of numbers from education and examination. We did a comparison from 2015 to 2025, 10-year look. In 2015, there were 516 barber and cosmetology schools. In 2025, there were 1,185. That's a 130% increase with the same 18 folks in education and examination. 45,435 exams were administered in 2015, just in barber and cosmetology. That's our largest program, so it's one to focus on. 79,920 in 2025, a 76% increase. Next, I will talk about licensing. Licensing division with 67 folks. Our latest numbers show that there are 524 applications to be processed. And in February, there were 21,161 February new licenses issued and 40,641 renewals issued by the team in licensing. So I just want to say thank you to everyone for making our first word, the Department of Licensing, shine.
Standing.
Incredible.
Susanna has our last update.
Chair, one last question. Where's your director, who is doing a fantastic job on licensing?
We're joined today by Deputy Director Katie
Thank
Price
you.
of Licensing. Heather Muir, Director of Licensing, had other appointments to be in.
Katie, thank you. Please let Heather know how impressed we are. Thank you.
Chair, if you look at it, the numbers are astonishingly very, very low right there. It's not the issue of them, our staff, but probably the licensees themselves. Richard.
Good afternoon, Susanna Catron, Deputy Executive Director for Regulatory Services. In the spirit of serving Texans faster and more efficiently, I want to applaud the three divisions that I supervise. Their vacancy rate is now down to an average of 6.3%. It was in the double digits at your last two meetings. So thank you to the hiring managers and thank you to HR for it goes into hiring quality staff for your team. The regulatory services divisions continue to keep pace and or exceed performance in comparison to this period during the last fiscal year. Field inspections has reflected an increase of 354 additional businesses inspected from this time last year, primarily in barbering and cosmetology. Enforcement's average time for closing complaints is now under 200 days, and the team's work to respond to consumers and negotiate full and fair resolution with licensees is very commendable, given the volume that they have on their dockets. Couple of items from compliance. Inspectors Bill Weatherly and Troy Smart went to Laredo to address the Laredo Area Contractors Association about the unlicensed activity occurring in that community recently. They had a very good reception and provided both presentation and Q&A with the licensed contractors there in Laredo. And we recently celebrated David Gunn, who after 39 years of dedicated service to the state of Texas and TDLR retired. So that was a big loss for the agency, but exciting for him. And I wanted to thank staff who have provided support and resource testimony at the legislature this session. They include Ron Foster, John Medlock, Jessica Hurtado, Elizabeth Wiggins, Charlotte Melder, Steve Eaker, Ford Strawn, and Chris Russi. So thank you for the opportunity to report, and I'm happy to answer any questions that you have.
Outstanding, all-star team.
Chair, one question, I think, with respect to the enforcement, the last couple of times we've been seeing at 54 to 57%. I think right now you're at about 64 or 65%. Is that a fair statement? We're moving up. I think let's also get it cleared up. Thank you.
Great.
Stan, you're doing a great job. Thank you.
All right. Courtney?
That's all of our updates.
That's it?
That's it.
All right, great job. Hey, team, outstanding job. Commissioners, our next meeting will be the 20th. We're gonna see what that agenda, I'll talk to Doug about making it, combining it, if that's possible. It's a great idea. Cannot tell you guys what an outstanding job you guys have done. I know it's a lot and there's more to come. Hang in there. Legislation's almost, I don't know, how many more days left do we have? Bruno? No. Oh yeah, you don't keep track of that anymore.
Good second. We should have a clock. Yeah, we need a clock.
The clock ticking. So we'll keep you posted on the next meeting, and I'll take a motion for adjournment.
So moved.
Second? All in favor, say aye.
Aye.
Okay. Here, we're adjourned.
Good job, Chairman. We got a lot done today.
We did.